Yes. Saying for lifting one urgent motion matter.
Motion.
Yes.
What is the subject?
Subject plus the railway department eviction order. Lord.
Eviction.
Yes.
Bench five.
Lordship, with the consent of the other side, we pray for a short accommodation at number 7, your Lord.
Okay. Mr. K.P. Basak, standing counsel, KPDC, has sought for adjournment for a week,
For a week, your Lord.
maybe after vacation, 2017 matter. After 2 weeks, it is submitted that consent has been taken from the land council for the petitioner to make the prayer. This is the case after 2 weeks.
Lordship, I like to mention contempt case number 349 of 2023.
Huh?
Contempt case number
Yes.
349 of 2023 and 350 for listing. The matter pertaining to royalty. So, kindly
Royalty. Of which year?
2023.
Huh?
23 or
2023.
and
Maybe last week before.
highlight.
May I please Lordship, I am mentioning for listing dismiss from his service. So matter may be passed over next week.
Which one? Yesterday.
Next week.
For listing or adjournment? Possible? Huh?
Mentioning dismiss from his service. Mentioning.
Dismiss from service?
Sakshi Kulita.
Dismiss from service? What does the petitioner do? State government employee? Bench 3. This is not the proper bench.
Supplementary list of withdrawal item number 9.
I have instructions to include.
Mr. Didas, learned counsel for the petitioner has submitted that he has instruction to withdraw the writ petition. So, Mr.
A. Borwal,
A. Borwal, learned counsel for the respondent number
1, 3, and 4, Sibsagar Municipal.
1, 3, and 4. MNS and MS Sharma and Junior Government for Assam for the respondent number 2 are present. So, in view of the submission made by Mr. Das, learned counsel for the petition or petition is dismissed. On withdrawal.
10.
Same.
Item number 1 for admission.
Yes.
Please tell us. So, regard to settlement, the petitioner, the president of the Korea Group History, the president. The respondent number 2 asked an interim order. You will find.
Pension বন্ধ শব্দবোৰ ডাঙৰ হৈছে পইচা চাওক কি ক'লে মানে
There is 37 even.
37.
page 30.
But please.
One of the shareholder society,
Novo Kumar Das.
Kumarta.
Hmm.
He is the shareholder.
From you are saying?
Fine.
Where from you are saying?
You will find page 35 here.
Which name?
The title portion is Devota, serial number 90.
Devodas.
Devota,
Hmm.
son of Haren.
Hmm.
He is the shareholder of the society.
Hmm.
As per the norms of the society, as well as the tender. If he has no locus standi to file the tender, even. As because he is a shareholder. Yeah. As a shareholder, he cannot. It is proof that he by impersonation, you know,
Impersonation.
impersonation. Devodas, son of Horenda.
Ah.
Here, Novodas, son of Horenda. It is clear.
Hmm.
Father's name is Horenda. Here, name is impersonated. But person is one. But by taking two names, he settled the fishery in the name of Novokumar. But as per the voter list, page 35,
Hmm.
he has no locus standi to file the tender.
Hmm.
As per their norm, as per tender notice, tender notice you will find page page 22, you will see.
Is
Page 20,
20. 20.
22,
Huh?
22,
22.
Ma'am.
Yes. Okay. Clause 4.10.
clause 4.10 you will marry. কমিটির কোনো সদস্যই ব্যক্তিগতভাৱে নিবিদা দাখিল কৰিব নোৱাৰে। কোনো কাৰণত কমিটিৰ সদস্য হিচাপে প্ৰমাণিত হলে তেওঁৰ নিবিদা নাকচ কৰা হয়। He is a shareholder, member of the society.
And how to do Pramanito?
Pramanito, you will achieve will page 35 you will.
Devodas, Horendas.
Horrendous. Father is horrendous, but by name Devodas. Actually, Novodas, but by name Devodas, by impersonation, he in the name of Novodas filed a tender.
So, Pramanito Hole,
My
it is to be proved.
lord, Pramanito, the certificate given by the you will find
Yes.
page hereafter page 46 you will achieve. Page 40. Married.
Horendas has 4 sons. Now you say that Devodas, alias Novokumar.
Novokumar.
Many shareholders
My
submitted a complaint
my
to the society.
my on hereafter another complaint your lordship page page 56
Page 56.
my relating to Kumocha group property
Resolution
my lord
taken by the society was forwarded to the
my lord
managing director.
my lord.
Which resolution
Resolution your
pertinent.
lordship will page 58, your lordship.
পত্তন দিছে যদিও জালিয়াতি কৰা লোকৰ পৰা নিৰ্মাণ সম্পাদিত সাংবিধানিক নথি।
Proposal to
Read 63, page 63. যিহেতু কমতীয়া গ্ৰুপ মীনমহলখন
my lord. Here, Kumutia group.
সুবিধা যোগে দেৱদাসক উৰ্ফে
My lord.
নৱদাসক
হয়।
পত্তন দিছিল যদিও আমাৰ কুমতীয়াৰ হিচাপ ফিচাৰী সমবায় সমিতিৰ সঞ্চালক মণ্ডলীয়ে উক্ত জালিয়াতি কৰা লোকৰ পৰা মীনমহল পত্তন বাতিল কৰি সমিতিৰ নামত পত্তন দিবলৈ সভাই
From Min Nigamo.
So there are two prayers. First is cancellation of settlement
Right.
in favor of Devadas alias Navadas.
Right.
And secondly, to give the settlement in favor of the society.
Right.
So second prayer, since
Right.
you have not submitted any tender, you cannot make prayer for settlement.
My lord. We cannot submit the tender due to the formation of the constitution of the society. Your lordship. That is why as well as they have told
But the
us,
respondent says you did not deposit the kist. so-
they showing that we are defaulter. But they have not cancelled our settlement. Your lordship. I may be defaulter, but they have not declared that we are defaulter. As well as they have not
But
cancel
Some
our
kist money was payable.
my lord.
Some kist money was payable.
My lord, earlier, we are continuing in 3 years, your lord. The term is 7 years,
Extended also.
my lord,
Extended also.
but without cancellation of our settlement, your lord. How they have,
So what should be the forum for proving that he has done impersonation?
my lord,
What should be the forum?
impersonation, your
Orenda's
lordship,
4 sons, 5 sons, who will decide? will decide.
respondent number 2, your lordship.
He-
Respondent number 2.
He is not court.
Please,
You are alleging impersonation.
my lord.
He is not court. Managing director FDC is not court, judicial authority to decide, give a verdict that impersonation has been
We
committed.
have submitted our complaint. As we are the registered society, we are not the individual, your lord.
Then what about
We
the
have
other
some right.
documents? Mr. Chaudhary, what
Right.
about the other documents that private respondent has submitted along with his bid?
Fine.
Along with his bid?
He may be
Come
submitted,
to
but
say-
he has no locus standing to submit
Come-
the bid.
Come,
Because neither they cancel our settlement.
come to 107.
Neither they
come to
cancel our
hun-
settlement.
Come to 117. Come to page 107.
107 of our,
117. Or their affidavit. His affidavit
fine.
in opposition.
I'm taking.
Annex are 8.
Hundred seven.
107. Annex are 8 of their affidavit in opposition.
My lord.
What do you say about this? Forced.
107, this is the affidavit.
117. Annex are 8. Or come to Annex are 8 of their his affidavit in opposition.
My lord, 117.
Not 117. Annex
are
are 8.
Annexure.
What is this?
This is the work birth certificate,
This is forged,
death certificate,
not date.
birth certificate.
But,
Date of,
but this is forged.
no, my lord, birth certificate, but.
This is forged or what?
Birth
This
certificate,
this is in existence.
my lord, birth certificate may be corrected, but they have.
Come to next page.
According to the.
Next page. What is this?
Page, my lord,
Next page. There is another certificate.
18. Admit card.
What is this? Admit card.
Admit card.
This is forged.
Date of birth maybe,
No, date of birth is not the issue.
but they have.
Date of birth, Mr. Chaudhary, date of birth is not the issue. It is Navakumar Das, son of Horen Das, that is the issue.
Fine. Fine.
What does it reflect? Either Annexure 8 that was registered on 12/3/2007. Navakumar Das, son of Horen Das. Annexure 8, birth certificate. Admit card that was issued perhaps in the year 1997.
Right.
1997.
Right.
It reflects Navakumar Das is the son of Horen Das.
Right.
Then come to next page. Navakumar Das, care of, there is Aadhaar. That was issued on 24/1/2020,
Right.
prior to the tender notice.
Right.
So he is care of Horen Das.
Right.
Then what more? What is next? Voter list.
Total list.
Voter list is Navakumar Das, son of Horen Das.
Right.
Now,
As you see, as you lordship will see,
Huh?
55 years.
now who will decide? Horen Das is son of Navakumar Das is son of these
have-
four documents prima facie reflect that Navakumar Das
Right.
is a son of Horen Das.
Other
And
same-
secondly,
Correct.
your allegation is that Devodas
Right. Son
is
of
the
Horen.
son of Horen Das.
Right.
So Devodas is and Navakumar Das is one and the same.
Right.
Right?
You will.
And whether or the what kind of questions are these? Disputed questions.
Disputed.
Who will decide?
Right.
Read code will decide. Tell me, this leading of oral as well as documentary evidence. We cannot, sitting in read proceeding, can decide that Navakumar Das impersonated as Devodas or Devodas impersonated as Navakumar Das, and thereafter got the settlement.
Right.
Settlement is secondary. Next thing. First thing, we have to decide Navakumar, whether Navakumar Das is Devakumar Das. Right?
Right.
And both sides, you have made some signature and say that Navakumar Das and Devodas is one and the same. His documentary evidence from some certifying authorities like the births, register of birth and date, Board of Secondary Education, those documents reflect that Navakumar Das is a son of Horen Das. So
It is correct.
there,
We have
a person exists in the name of Navakumar Das.
We have no question regarding.
No question. Then how we decide in read code?
Look, sir,
Show me any impersonation can be decided. Show me any case of impersonation can be decided in a read proceeding. Any,
My lord.
any, not Guwahati High Court,
Right.
Supreme Court or any High Court.
Right.
Or maybe House of Lords also, Privy Council also.
Right.
Or American jurisprudence also. Show me any authority. One judgment. That this impersonation issue can be decided in a read proceeding, which is an extraordinary jurisdiction and discretionary.
Our honorable division bench also you will find. Honorable division bench.
Yes.
Honorable division bench.
Which judgment?
You will find. In my affidavit in reply.
Affidavit in reply.
Reply. My lord.
Okay. Affidavit in reply.
Page 139.
130.
Page 40.
139.
140.
140.
140.
Huh.
May I read it?
Yes.
The present appeal has been prepared against the order dated demand passed by the learned single judge in WBC number so by which the learned single judge vacated the earlier interim order passed on 25/11/22. Considering the nature of the case
Hmm.
and dispute
Hmm.
which has arisen, we are of the view that it will be more appropriate that the learned single judge may proceed to decide the matter on merit in view of the fact that the identity of the respondent number three,
Hmm.
in whose favor the settlement was made, has been questioned
Hmm. Read further.
by division bench.
Read further.
This being a disputed
Ah.
question of fact, it will
That is
be
the most
more
important.
appropriate if the
That
learned
is-
single judge consider
Ah.
the same rather than ask at this stage. Accordingly, without interfering with the order dated demand, the learned single judge so and so, we request the learned single judge for expedient disposal of the
Right.
matter.
So division bench has observed this is a disputed question of fact.
Mine,
Right.
mine,
Some disputed question of fact
mine.
can be determined in a written proceeding. But
Definitely.
the nature of the disputed question of fact
Right.
is to be looked into first. And thereafter to decide whether it is a proper case to decide the repetition on such disputed question of fact.
You lordship will.
Any division bench has been? This is the division bench. You have referred to this one.
Mine.
Okay.
Then you lordship will find.
You have rightly pointed out.
Right.
You have rightly pointed out. I did not read it earlier. Okay, then
You lordship will find.
anything new? Anything new?
I'm submitting you.
That day the case was adjourned because you were supposed to submit a number of decisions.
My lord,
What are those decisions? Only on that count we had adjourned the matter, MS Bhattacharya.
Yes, sir.
You wanted to show number of decisions.
my lord. I have.
Which are those decisions,
I-
please? Telling the same thing will not
My lord.
give weight
My lord,
to the submission already made.
my affidavit in reply page 138, your lord.
These are resolutions.
My lord. Resolution.
Ah.
যেহেতু গত পরিচালন সঞ্চালক মণ্ডলী
Was this Navakumar Das was present in these meetings?
my lord.
Was he present?
I have that, my lord.
Was he present in the meeting?
My lord, no.
Not present. So every resolution was passed behind his back.
Devakumar Das present, your lord. Devakumar Das present,
Where is?
my lord. I have that,
Show me his signature.
my lord.
He has accepted the position.
I'm giving it.
Don't come straight away point out.
Page 149, your
149.
my lord. In the meeting of the general meeting, your lordship,
Where is that? Debo.
page 151, your lordship,
Ah.
serial number 275.
Who is this?
Debodas.
Debo is not there. Something, then you.
No, my lord, Debodas,
You, some you.
not you.
Duba.
He,
If it
he
is
signed-
first one is D, then it is Duba.
No, my lord, Debo, this is the BA, DEBA link. Here, write the
What?
DEBA, Debodas.
You don't force me to read you as E.
No, my lord, this is,
This is you.
no,
It
no,
is clear to the naked eye.
no, my lord. His,
How? No.
his father also.
Do you read this? You write this as E. You write E like this.
No, this is.
Do you write
He writes
E?
some,
Ah,
this is the Debodas.
this is two purpose. Anything new?
You lordship.
Anything new?
Original.
Any other,
So 270.
any other submission?
270 Horrenda. His father, you know,
We don't know who is father. There may be number of horrendous.
his father and he is a shareholder of the.
Who will
society.
decide, Mr. Chaudhary?
The respondent number 2, my.
Who? He is judicial authority.
Respondent
This
number,
is a serious allegation about impersonation.
we are the registered society.
Do you know section 419 IPC? No, IPC 419 perhaps. What is 419?
Yes.
What is section 419? Ah, 416. 416 and 419. Cheating by personation. Any person is said to cheat by personation if he cheats by pretending to be some other person or by knowingly substituting one person for another or representing that he or any other person is a person other than he or such a person really is. Then 419 is the punishment for 3 years. Who will decide all these questions?
No, my lord.
You file
There is a rule in the society.
role in the society.
Society, in the even tender also. That
Mr. Surri, I have
I'm giving you a
adjourned the matter because you are supposed to submit some decisions.
proceeding number 3, you will see page 138. It is clearly stated. যিহেতু গত পৰিচালন সঞ্চালক মণ্ডলীয়ে যোৱা 21/3/22 তাৰিখে কুমতীয়া বিলৰ 4 মাহ নিৰ্ধাৰণ কৰি উক্ত মেইন মহলখন সমিতিৰ নামত 1 বছৰলৈ ম্যাদ বৃদ্ধিকৰণৰ বাবে অসম মীন উন্নয়ন নিগমত আবেদন দাখিল কৰা আছিল যদিও নিগমে সমিতিক জানিবলৈ নিদিয়াকে যোৱা ইংৰাজী 5/4/2022 তাৰিখে নিগমে নিবিদা যোগে ব্যক্তিগত লোকক কুমতীয়া বিল আবণ্টন দিয়ে এই মৰ্মে সঞ্চালক মণ্ডলীয়ে আলোচনা বিলোচনা কৰি সভাপতি ঘনদাসক মহামান্য গুৱাহাটী উচ্চ ন্যায়ালয়ত গোচৰ ৰুজু কৰিবলৈ আজি সভাই
Mr. Chaudhary, I'm just asking one question. When the first resolution you have taken?
My lord.
First resolution you have taken when? Against Mr. Nobodas? When?
28 2020
20?
8
Which page?
page 137.
137.
Resolution of যিহেতু কুমতীয়া ফিচাৰী সময়
Which resolution? Third resolution.
third resolution.
Did you take any resolution to expel him from the membership?
My lord.
Did you take any resolution
Right.
to expel him from the membership or to cancel his membership? Because you have started taking resolution against him
My lord.
since August 2022.
My lord.
Did
This
you
was-
take any resolution for his expulsion?
This was placed before the respondent number
No, no.
2.
Yes or no? When court asks a question,
Right.
you should answer either in the affirmative or in the negative. So, did you take any resolution for expulsion of this Navadas from the membership of the society? Did you?
My lord,
Did you? Yes or no? Have you understood my question?
no, I'm not, I'm confident.
You have started taking resolution of this kind since August 2022,
Right.
saying that Navakumar Das
Right.
had impersonated as Devakumar Das
Right.
to get the settlement of the fishery,
My lord,
right?
my lord,
So this is clearly an act
Right.
on the part of a member, shareholder of a cooperative society
my lord,
against the interest of the society.
my lord.
So did you take any resolution for expulsion
Right.
of Devakumar Das or cancellation of his membership from the role of members of the society? Yes or no?
So we have
Yes or no?
several, yes, my
It
lord,
is, it can be answered only yes or no.
yes, my lord.
Where?
We have submitted
Where?
several,
Where, Mr.?
you lordship,
Don't divert the issue. Where? Mr. Chori, please hand over the decisions which you wanted to show
Fine.
today.
nineteen 88 1 year.
Hand over a copy.
I have only one copy, you know.
For what purpose you want to rely on this?
Because without, we have submitted representative before the respondent authority. But without disposing of the representation, they cannot settle the fishery. First, their duty to dispose our representation and our allegation.
What kind of representation you
we have
submitted?
submitted?
What kind of representation?
That one Navodas and Devadas, same person, is
okay.
impersonated the society.
Okay.
That is why we have submitted the representation before the.
Any other?
Part two.
This is nothing to, this judgment has not touched anything on that aspect.
Fine. Then 2000,
Absolutely irrelevant.
1998 1 GLR, your lord. Page 129, your lord. Regarding the deserving person,
Huh?
they are the poor person, your lordship, the fishermen, actual fisher, 100% fishermen, your lordship. They have no alternative to go anywhere. They are the registered society under the respondent number 2, your lordship.
Why did not you participate?
Participate, this is, that is why they said that we have not paid
This is too much. Mister, I'm not going to hear
due to the
here unnecessary things.
due to the natural calamities, your lordship.
What do you want to show? What do you want to show from this judgment?
My lord, I have not.
What is the ratio of this judgment? What it says discussed?
I have no another copy. You will lordship.
Huh?
You lordship.
You are referring to 1998 1 GLR 129?
My lord.
Huh?
Fine.
I am having it. What is the ratio? 1998 1 GLR 129. Is it not?
My lord.
So what is the ratio you want to rely?
Regarding settlement.
Settlement,
My lord.
but the entire judgment,
My lord.
entire judgment is is in reference to Rule 12
Right.
of the Assam Fishery Rules 1953.
Right.
Now, where does Rule 12 is involved here? Where?
Let me explain your lordship. I have not an extra copy. Your lordship.
What do you want to explain? Please tell me where everything is on Rule 12 Assam Fishery Rules. Are we dealing with Rule 12 here?
My lord.
Why?
Because Rule 12 is the. I have no extra copy. That is what.
1998 1 GLR 129?
My lord.
Is it?
Correct. Correct.
Headline,
My lord.
head note. Please read. Head note.
No, I have not extra.
No, head note. Head note, head note. You read the head note.
1991 GLR. Yes.
Head note.
My lord. Fishery rule. 2000. Power of the government.
Fishery rules? Rule
Rule 12.
12. Now,
Power of.
now. Where is Rule 12 involved here? In this case,
Para 7. You will.
no. Mr. Chaudhary,
para 7,
in this case,
my lord.
where Rule 12 is involved, in your file,
My lord.
this file, where Rule 12 is mentioned, now I have to cut short the time, 5 minutes maximum. This is going on for half an hour.
Para 7, your lordship.
Para 7.
Right.
No, in their document.
In their document,
Para 7 in your petition.
my lord, my petition, your lord.
Para 7, what does it say? That same thing, Horen Das, Norma Kumar Das, Ranjit Das, Sagar Das, Devodas.
My lord.
Para 7.
My
Not about Rule 12. Mr. Chaudhary,
Right.
let me be clear. You will not find any reference of Rule 12 in the tender process initiated by AFDC. It is not a 60% category fishery. So all these observations are in respect of 60% category fishery. Socio-economic, objective, beneficial legislation, Maimal community, scheduled caste, all these are Rule 12 and those are in respect of 60% category fishery,
Right.
not in respect of fisheries pertaining to AFDC. Because of Rule 8B, 8C of the Assam fishery rules.
Minor thing, Lordship. In his petition, Lordship, he has admitted para saying that Navakumar Das is the page number 6, Lordship. Kindly go to it. He is admitting that Navakumar Das is the original person. In page number 6, in the cost.
I have seen it.
And-
Horen Das has 4 sons.
No, he is admitting the Navakumar Das and page para number 6. And he has stated that Devak Das, from the petition itself, it's a contradictory, Lordship. Navakumar,
Right. He is want to say, portray that Devodas and Navakumar Das is one and the
but
same.
that
That is all.
is
So impersonation, if we go on impersonation, then we have to ask Horen Das to stand in the witness box here. And all his 4 sons, all the shareholders
My lord.
of the society,
Then my lord.
we have to fix a witness box here and we go on recording their oral evidence.
You,
Right.
you lordship. will have-
Anything more? Yes.
Then you
The
lordship may
5 minutes
verify-
is up.
You lordship.
5 minutes is up.
Maybe verify you lordship. My another petition you lordship. 2012 3GLR your lordship.
Head note.
A judicial review,
Ah,
administrative action.
Yes.
Not open for the court to sit. Where the administrative action or non-action on the part of the authorities unless that suffer from bias, discrimination or
Mr.
arbitrary.
Chaudhary, Managing Director, AFDC should have the authority to decide and the disputed question of fact, whether Nabakumar Das is
Right.
Devodas. He does not have the authority, jurisdiction. He cannot assume a jurisdiction of a quasi-judicial authority.
Respondent number 2 can. He is the authority to decide the matter.
Yes,
So matter may be placed before the respondent number 2 to decide the
Argument.
matter, Your Lordship.
My lord,
recorded.
my lord.
Argument recorded.
My lord, I raised a preliminary question regarding maintainability. He answered in affidavit. So since it is sent back by the division bench, so I have a locus standi. That is his reply. So in fact, that division bench order clear that is a disputed question of fact. So everything goes against him, my lord. And so far, my lord, your lordship kindly see the earlier settlement holder is the society. Society is not.
What is the
coming-
history? What is the history there?
My lord,
What is the history of their settlement?
history of settlement there in their petition, my lord.
Ah,
Yeah, they have stated that our earlier the society, it was their name, my lord. It was the 2011 Kumutia Gaon fishery was settled with the para 3, my lord,
7 years.
my lord. So, but society
But after expiry, again resettled for office note 31/3/2012. Suffered financial loss and did not benefit as some part of the affected. Society paid for some extension to enable them to pay the remaining balance amount to the government,
my lord.
but without extending the time. It was
1091.
issued increasing the rate of so and so and so and so. Okay,
So their society is not before your lordship,
so balance amount remained.
my lord. So that's why, my lord, society not come to the court, my lord. But his individual capacity came before this. He shown a one resolution. That resolution which was shown by him, my lord, your lordship kindly see. That is reflected that, my lord. For your lordship kindly see that page, my lord, 138. 138. I'll read the vernacular question which was his shown, my lord. 138.
38.
যিহেতু পৰিচালনা সঞ্চালক মণ্ডলীয়ে যোৱা 21/3/22 prior to that tender was issued, my lord. তাৰিখে হুকুমতীয়া বিলৰ চাৰিসীমা নিৰ্ধাৰণ কৰি উক্ত মীনমহলখন সমিতি নামত 1 বছৰলৈ ম্যাদ বৃদ্ধিকৰণৰ বাবে অসম মীন সমবায় সমিতিৰ আবেদন দাখিল কৰা আছিল। যদিও নিবেদনকাৰীয়ে সমিতিৰ জানিবলৈ নিদিয়াৰ যোৱাত 4-5-22 তাৰিখে নিগমে নিবেদনৰ কোনো ব্যক্তিক লোকক কুমুটীয়া বিলৰ হিচাপত আবেদন দিয়ে। এই মৰ্মে সঞ্চালকৰ মণ্ডলীয়ে আপোনাক বিবেচনা কৰি সভাপতি ঘন দাসক মহামান্য গুৱাহাটী উচ্চ ন্যায়ালয়ত গোচৰ ৰুজু কৰিবলৈ সভাপতি কৃতিত্ব দিয়া হ'ল। প্ৰকাশ থাকিব যে প্ৰয়োজন অনুসাৰে দিলে So regarding non-granting of extension, he was asked to file a case regarding not dispute that so and so is the same one and same man. Very interestingly, my lord, there is a certificate I have annexed, my lord, from their society of their, my lord, secretary of their society give a certificate, my lord, page 108. In our page 108, my lord.
Regarding that, we have also annexed some
মই
certificate.
আপুনি
Your
কোন
Lordship.
কম মই আপুনি ডিস্টার্ব কৰা নাই আপুনি কৈ লওক শেষ কৰি লওক 108, there is a certificate issued by the secretary Puniram Das, secretary Khumtai Fishery Kumotia Fishery Somobai Samiti, his committee, my lord. That, my lord, this is hereby certified that Nabakumar Das, son of Sri Horen Das, resident of so the associate person is not a member of our shareholder of our Kumotia Fishery Society. So his society secretary has given this certificate. I have annexed my lord, my birth certificate, my SSLC certificate, my Aadhaar card, my lord, my voter card, my lord. Now he says that if he says that Tanmoy Mohanty is same with my lord, Mr. Sharma, Bhaskar, my lord, Banjal Sharma, how can I, my lord, prove it, my lord? So I have my legitimate document. I applied for tender document in my name of Nabakumar Das. Page 79. Your lordship kindly see. Settlement was granted in my name. More so, my lord, he filed this case, questioning, disputed question of fact. Also, my lord, he is not joining the tender process, my lord. Number 1. Number 2, my lord, he did not challenge the tender process, my lord, because his claim is for extension.
His pair is for extension, my lord. He is
No,
not
here it is not the claim for extension.
here not claim, my lord. Their representation, my lord. No, here they want settlement, my lord.
Settlement without participating in the tender process.
My lord, my lord.
Settlement
But-
without participating in the tender process.
without challenging the tender system, my lord. Tender process, my lord.
Allow the petitioner society to continue.
Yeah, yes, my lord. For extension, you allowed us petitioner society to continue.
Page 15.
Page 15, my lord. Their society did not take any resolution that one and this is the same man, we file a FIR. We'll go to civil suit. That is not been done. That is a question, this was a question created by him, my lord. In fact, my lord, Gaon Buddha will be another Gaon, my lord, village, my lord, giving a certificate that he is not the one and same man, my lord. Then I approached that. So yes, what is this? Then he rectified and says, no, he rectified this certificate. And two certificates which they have annexed, my lord. One is by his brother, one is by his brother, one is by his friend. And another thing, my lord, you will kindly see one independent person, he is giving a certificate. The Gaon Buddha, he's annexed, my lord. I'll just show that, my lord.
Everybody is giving certificate.
No,
But
everybody,
Everybody is giving certificate, everybody is.
one Gaon Buddha giving a certificate in his favor.
No, what
Now,
about, I am saying.
so these are disputed question of fact, my lord.
These are claims and counter claims.
My lord.
Mr. X is giving certificate in your favor, Mr. Y is giving certificate against you. But so far as birth certificate is concerned,
My lord,
and
that
the
cannot be-
Board
that-
of Secondary Education,
and Aadhaar
documents
card,
are concerned,
and Aadhaar card,
that has primacy value that Mr. Navakumar Das is the son of Horen Das.
my lord.
Now, he has to dislodge it by leading evidence. It is purely a disputed question. These are claims and counterclaims. Mr. X is saying, everybody is saying, issuing certificates, left and right.
At a 24, at a
My lord, these are the two judgment on disputed question of High Court. Honorable High Court cannot, my lord, interfere, my lord. They are the judgment. This is-
Yes, Mr. Sharma,
This is two judgment.
are you the authority to
Yeah,
decide
yeah.
what Mr. Chaudhary says? Will the judicial power also?
No, no.
Huh?
We don't,
Under IPC
no lordship,
or CPC?
nothing.
Huh?
We don't have any power.
You have been given some power under CPC.
I don't know lordship. If Sodri gives, I don't know.
Whether response number 2 has been given the authority under jurisdiction under CPC to record evidence, anything? Or to, because it is impersonation.
Right.
Your allegation is impersonation. That is serious allegation. Not unlike that he does not have Akijai, he does not have land.
Regarding that various certificates.
This is impersonation. Navakumar Das is Devadas. That is serious allegation.
Right.
And so many conflicting documents are there. You are saying Navakumar Das, son of Horen Das, and Devakumar Das, son of Horen Das, one and the same. He is furnishing document. Navakumar Das is Navakumar Das. He is not Devadas.
One of
So who will decide?
one of the person also file an FIR. You will-
Oh, good. That should be brought to its logical conclusion.
Because
Thereafter, you may have a cause of action.
they have suspended the person, why he issued the certificate.
So let it be brought to its logical conclusion. Thereafter, you will get a cause of action.
Then my humble submission. Before
Definitely, it will give rise to a cause of action.
refer the matter before the
Unless till he is
respondent number,
convicted.
respondent number to decide the matter,
Uh,
because he is the competent authority. Right.
Yes, Mr. Sharma.
I'm
anything?
not the competent, I cannot do, even in the case of register also, we cannot do
Right.
anything. Anything which is,
Various certificate also given in favor of.
The
he is in the mood of giving power. to us.
Present writ petition. Under Article 226 of the Constitution of India is prepared by the petitioner in his purported capacity as the president of Messrs. Kumotia Group Fishery Cooperative Society Limited, a cooperative society registered under the provisions of the Assam Cooperative Societies Act 1949/2007. Full stop. In this writ petition, the writ petition has been preferred. Assailing an order of settlement dated 9/6/2022, whereby the respondent, Assam Fisheries Development Corporation, within FDC Limited, had settled a fishery Kumotia Group Fishery, situated within the district of Dhemaji, in favor of the respondent number 6. Full stop. The petitioner has also made a prayer for a direction to the respondent, FDC Limited, to continue the settlement of Kumotia Group Fishery with Messrs. Kumotia Group Fishery Cooperative Society. From the pleadings, in the writ petition and the affidavits, the affidavit in opposition, affidavits in opposition and affidavits in reply, it has emerged that in the year 2011, the respondent FDC Limited published a tender notice number 1/2011 on 7/5/2011, inviting bids for settlement of the fishery named Kumotia Group Fishery, within bracket heading after referred to as the fishery. And in the said tender process, after conclusion of the said tender process, the fishery came to be settled in favor of Messrs. Kumotia Group Fisheries Cooperative Society Limited, Dhemaji, for a period of 7 years. After expiry of the original period of settlement of 7 years, the fishery was again settled. Now the period of settlement was extended. Period of settlement made in favor of Kumotia Group Fishery Cooperative Society Limited was extended till 31/3/2022. by an office order dated 29/5/2019. Full stop. It is projected that as Messrs. So Society was unable to deposit some certain installment amount, it made a prayer for extension of the settlement period to enable the society to pay the remaining balance amount. Full stop. Without giving any extension, in favor of Messrs. So-and-so Society, the respondent AFDC Limited published a tender notice dated 14/3/2000 for tender notice number 1/2022. Whereby dated on 14/3/2022, whereby tenders were invited for settlement of a number of fisheries, for 54 number of fisheries, including Kumutia group fishery. Full stop. It is pertinent to mention that when the tender process was undertaken in the year 2011, the minimum annual revenue for the fishery was fixed at rupees 1,38,000. 2011 will question. When the full stop. By the tender notice number 1/2022 dated 14/3/2022, the minimum annual revenue was fixed at 11,35,420. The tender process initiated by the tender notice number 1/2022 for settlement of the fishery had culminated in an order dated 29/5/2000. Nine 6/2022. Issued under the hand of the respondent number 2. Whereby the respondent AFDC Limited offered the settlement of the fishery to the respondent number Mr. Mohan, response number six. Yes.
Six.
Response number 6. For a period of 7 years,
Seven.
at his offered bid value of rupees 13 lakh 30.
1,33 lakh.
What is the total value? 1 crore 33 lakh. In total, for the period of 7 years. By the offer letter dated 9/6/2022, the respondent number 6 was asked to complete the formalities like deposit of 25% as towards first installment, 25% of the annual revenue towards first installment, 25% of the annual revenue as security money, and a bank guarantee within a stipulated period of time for execution of the lease agreement. Full stop. What is the final order of settlement? The respondent number 6 had accordingly submitted the demand draft two demand drafts for amounts of rupees 1,10,000 and rupees 4,75,000,
And thereafter, final order was issued by.
and both dated 15/6/2022, and a bank guarantee towards compliance of the requisite formalities, and thereafter, so after compliance of the formalities by the respondent number 6, as directed by the respondent AFDC Limited, the final or a final order of settlement, the final order of settlement dated 5/6/2022,
5/7.
5/7/2022 has been issued under the hand of the respondent number 2, whereby the fishery has been settled in favor of the respondent number 6 for a period of 7 years from the financial year 2022-2023 to the financial year 2028-2029. Full stop. At a total price of rupees 1 crore 33 lakhs for the said period of 7 years. Full stop. After the final order of settlement, or prior to that, you have taken position. After the final order of settlement, the petition respondent number 6 took over the position on the fishery, and as on date, as on the date of institution of the petition, he was running the fishery. Right?
Right.
Hard, Mr. R.M. Chaudhary. Learned counsel for the petitioner. Mr. M. Chetia. Where is Mr. Chetia?
He's here. Recording, he's one here. His name.
by Junior Government Bukit Assam for the respond number 1, 3, 4, 5. Mr. P. Sharma, the Standing Council, AFDC Limited for the respond number 2. And Mr. T.J. Mohantalal, Senior Counsel, assisted by MSP, Varasai Jilla Council for the respond number 3. Para. Mr. Chaudhary, Learned Counsel for the petition, has strenuously contended that Novo Kumar Das that is the respondent number 6 is also known as Debodas. Full stop. It is Debodas who impersonated as Novo Kumar Das had submitted the tender in response to the tender notice number 1/2022 and was offered the settlement by the respondent AFDC Limited. Full stop. Mr. Chaudhary has contended, by drawing attention to an extract of the voter list of Messrs. Kumutia Fishery Cooperative Society Limited. Annexer Roman 3 to the petition, to submit that Debodas, son of Horendas, resident of village Beveli, is a member of the said society. Full stop. As per, it is his contention that as per clause 4.10 of the tender notice number 1/2022 does not had a member of a cooperative society is not eligible to submit any tender individually in response to the tender notice number 1/2022. And if for some reason it is proved that he, the bidder, as a member, despite being a member of a cooperative society, has submitted his tender, then his tender would be liable to be rejected. Full stop. Mr. Chaudhary has further referred to a representation stated to have been submitted on behalf of Messrs. So-and-so Society with the signatures of a number of its members before the respondent AFDC Limited. Mentioning that since Navajit Das,
That is Navadin, another third person. It is not Navadin.
alias Devadas, son of Horendas, had, despite being a member of Messrs. So-and-so Society, Society, despite being a member of the society, submitted a bid, a tender in response to the tender notice number so-and-so individually, the order of settlement made in favor of the respondent number 6 should be rejected. Full stop. It was projected therein that one Horendas has 4 sons. One Devadas alias Navakumar Das, 2 Ranjit Das, 3 Sagar Das, and 4 Vikas Das. With such projections, Mr. Chaudhary has contended that the prayers made on behalf of the petitioner in the present litigation are to be allowed. Mr. Chaudhary has further referred to,
Representation, Your Lordship.
has further referred to some other documents annexed to the pleadings to buttress his such submissions. Mr. Sharma, Standing Counsel AFDC Limited has submitted that. No, Mr. R. Chaudhary has submitted that has contended that the respondent number 2 can very well examine and determine the question about, determine the aspect about impersonation act of impersonation committed by the respondent number 6 within bracket Navakumar Das as not committed by Devadas as Navakumar Das within bracket the respondent number 6 in getting the settlement of the fishery fraudulently. In response, Mr. Sharma and standing out. If this limited has submitted that the respondent was six, the text projected, text contended by the petition have clearly have given rise to a number of disputed questions of fact, more particularly, the dispute regarding impersonation by one person as another person, and the respondent number 2 is not best position to determine such disputed questions of fact which require determination with the leading of evidence. Full stop. He has submitted that the respondent number 6, while submitting his tender in his individual capacity, submitted all the requisite documents as per the terms and conditions of the tender notice number 1/2022. And as such, there is no question of recalling cancellation of the order of settlement made in favor of the respondent number 6 on the basis of such projections made on behalf of the petition. Mr. Mohan Tom, senior counsel appearing for the respondent number 6, has submitted that the allegation of impersonation is clearly misconceived. Full stop. In response to the tender notice number so and so, the tender notice number 1/2022 and the tender document had clearly mentioned the eligibility criteria for a bidder for getting the settlement of the fishery, and a number of documents were required to be submitted by a participant bidder along with his tender document. Full stop. The respondent number 6, in response to the tender notice number so the respondent number 6 has submitted all the requisite documents or certificates towards fulfillment of the eligibility criteria, as mentioned in the tender notice. The allegations made by the petitioner according to him, are in the realm of allegations only, and unless the same is proved, there is no question of interfering with the order of settlement made in favor of the respondent was 6. Also, I have given due consideration to the, and he has referred to, Mr. Mohanto has further referred to a number of documents annexed to the pleadings to buttress his submission that the respondent number 6 is has not resorted to any kind of impersonation. Also, I have given due consideration to the rival submissions made by the Learning Council for the parties and have also perused the materials brought on record by the parties to their pleadings. Full stop.
Main point was locus standi. He has not participated. Locus standi point is the main.
And Mr. Mohanto has further raised the question of maintainability of the writ petition. At the instance of the petitioner, such a writ petition at the instance of the petition, as neither the petitioner nor Messrs. So-and-so Society had participated in the tender process initiated by the tender notice number so-and-so. He has also referred, Mr. Patli, he has also referred to the resolution adopted by Messrs. So-and-so in its meeting dated
It is my lord.
1:30. Where is that? In the meeting dated 28/2022. To contend that the petitioner was never authorized to raise an issue as has been raised in the present writ petition. I have given. At first, reference can be made to the contentions made by the petitioner as regards impersonation of Devakumar Das as Devodas as Navakumar Das. Full stop. It is pleaded that Horrendous has 4 sons. 1 Devodas, 2 Ranjit Das, 3 Sagar Das, and 4 Vikas Das. As per the document mentioned as voters list of documents mentioned as an extract of voter list of Messrs. Kumotia Group Fishery Cooperative Society Limited for the year 2020-2021 document will be document has reflected that the society has a member named Devdas, Devodas, DEBA, Devodas, son of foreigners. In the representation dated 9/9/2022, Supra, the same allegations were made and it was claimed that Devodas and Navakumar Das were one and the same person. In the minutes of the meeting, held on 12/10/2022 of Messrs. Soweto Society, the same kind of claim was same kind of claim of impersonation was made. In the affidavit in reply, the petitioner has annexed the minutes of the meeting of Messrs. So-and-so held on 28/2020, which included a resolution to the effect that the society would make a prayer, would make a request before the AFDC Limited for extension of the period of settlement. For another 1 year. No, though the society submitted an application for extension of the period of settlement for another 1 year before the AFDC Limited. The AFDC Limited had settled the fishery in favor of an individual and therefore, it was resolved to authorize the petitioner to institute proceedings before the Guwahati High Court, as well as before the Honorable Supreme Court. Supreme Court also. Full stop. To in support of the contentions, a certificate dated 13/11/2022 from a ward member, number 10, Habeli, Pothar ward, Bhoboli Gaon Panchayat, 141 page. What is this 143? Who is this man? Who is he? Who is he? What capacity? 143.
43. Vikram Chutia.
Who is he?
Yeah, Gao Pradhan.
Huh?
Gao Pradhan.
You have not mentioned Gapuran. And a certificate dated 14/10/2022 of an executive member, Messrs. Kumotia Group Cooperative Society Limited. And a certificate of one ex-president, former president, Messrs. Kumotia, so and so, have been annexed. To as rebuttal to the contentions made by the petitioner, the respondent number 6. Has submitted a certificate of birth issued on 12/3/2007 by the Register of Birth and Date, Directorate of Health Service, Government of Assam, query, an admit card issued in the year issued for the purpose of the high school living certificate examination, compartmental examination, high school living certificate within compartmental examination, 1997, by the Board of Secondary Education Assam. And what is 119? Aadhaar. And an Aadhaar card issued on 24/1/2020. And an extract of the voter list published for village part 2, Hebeli Koiboto, under Dhemaji LAC.
Dhemaji 113 Dhemaji.
Dhemaji LAC, Dhemaji Scheduled Tribe LAC. To contend that to repel the contention of impersonation, as those documents have clearly reflected that Nava Kumar Das son of a person named Nobo Kumar Das, son of Horen Kumar Das, is in existence much earlier, from a time much earlier to the allegations made by the petition. We'll come back. 5 minutes. Is impersonation of one devotas by as by one Nobokumar Das, the within bracket the respondent of 6. The MDC, the tendering authority, that is, the respondent AFDC Limited is required to consider the responsiveness and non-responsiveness of the tenders received by it in response to the tender notice number 1/2022, which it had published for settlement of the fishery. The tender notice as well as the tender document mentioned a number of certificates, documents required to be submitted by a participant bidder to satisfy the eligibility criteria. Full stop. It is not the case of the petitioner that the respondent number 6 did not submit the requisite documents or certificates with the tendering authority as required by the tender notice tender document. The petitioner has not raised any question about non-responsiveness of the tender submitted by the respondent 6. What it has disputed, what the petitioner has disputed is the alleged impersonation of one devotas as by the respondent number 6 as Nobokumar Das. Where the documents which have been annexed by the petition do not go to prove that Debokumar Das and Nobokumar Das are one and the same person, as such allegations have not been proved in a manner required by law, meaning thereby the allegations made by the petitioner have remained are in the realm of allegations only. Full stop. One affidavit has been sworn by Horrendous on 19/5/2022, stating that he has 4 sons, 1 Navakumar Das, 2 Ranjit Das, 3 Sagar Das, 4 Manjit Das. Full stop. The statement sworn in the said affidavit is at variance to the allegation made by the petitioner to the effect that Sri Horrendous has 4 sons. One Devodas, 2 Ranjit Das, 3 Sagar Das, and 4 Vikas Das. Where does this Manjit Das came name? There is one Manjit Das again. 106.
So 106 is
Full stop. A certificate dated 2/4/2022 from the secretary, Messrs. Kumotia so and so, Ichari Cooperative Limited, is found annexed to the affidavit of provision, wherein the secretary, chief secretary, has certified that Nobo Kumar Das, within bracket the respond number 6, is not a member stroke shareholder of Messrs. Kumotia Pichari Cooperative Society Limited. The birth certificate issued by the Registrar of Birth and Death Director of Health Services has recorded that Nobokumar Das, with date of birth 1/1/1979, is the son of Horrendous, and the said certificate, birth certificate was registered on 12/3/2007. Full stop. The admit card issued by the SEBA has also recorded that Nobokumar Das is son of Nobokumar Das, who was to appear in the high school living certificate within bracket compartmental examination, 1997, he is a son of Horrendous. Full stop. The allegations made by the petitioner regarding impersonation would require pleading of negative evidence by the respondent number 6. For rebutting the allegation. Whereas such allegation requires leading of positive evidence for the person who has made the allegation. Full stop. Clause 4.10 has stipulated that it is only in the event it is proved that a member of the society has submitted a tender in his individual capacity. His tender would be rejected. Full stop. In the case in hand, comma, it is the petitioner has in the case in hand, comma, it is not the case of the petitioner that Nava Kumar Das is a member stroke shareholder of Messrs. So Society Limited. So what the petitioner has claimed is that one Devodas is a member stroke shareholder of Messrs. So full stop. The fact that Nobo Devodas has impersonated as Devokumar Das to submit the tender in response to the tender notice dated so and so, and has got the settlement, is to be proved in accordance with law. So it is only when such effect is proved as per law, comma, the clause 4.10 will get operational. And if the same is till the time the said fact is not proved, comma, clause 4.10 contained in the tender notice number so and so does not get operational. Full stop. As have been noticed from the rival contentions, comma, as has been noticed, comma, as has been noticed. So it is noticed that the rival respective contentions of the petitioner and the respondent number 6 haven't given rise to a number of disputed questions of fact. Though in a repetition under Article 226 of the Constitution of India, the High Court has jurisdiction to try issues both of fact and law. But the jurisdiction being discretionary and extraordinary, comma, has to be exercised only after consideration as to what facts are in dispute and what facts are not in dispute. Full stop. Such a stage comes after the exchange of pleadings in the form of affidavits among the parties, as a writ petition is ordinarily decided on the basis of affidavits. Full stop. When in a writ petition, if in a writ petition, disputed questions of facts arise which require appreciation of evidence, both oral and documentary. And for determination of such disputed questions of fact, if for determination of such disputed questions of fact, examination of witnesses are found necessary, then it may not be convenient to decide such disputes in a proceedings under Article 226 of the Constitution of India. And in such a case, the court may decline to entertain and try a writ petition. Full stop. It is settled that the High Court in its jurisdiction under Article 226 of the Constitution does not generally enter upon a determination of questions which demand elaborate examination of evidence to establish the right to enforce which the writ is claimed. Full stop. The present one is such a case which should require examination of several disputed questions of fact through both oral and documentary evidence, with examination of witnesses from the parties in a full-fledged trial. In such view of the matter, the present writ proceeding is found to be not the proper and appropriate proceeding to determine such kind of disputed questions of fact. There is another aspect which has been raised on behalf of the respondent number 6. Full stop. It is an admitted position as emerged from the averments made in the writ petition, that at the time of expiry of the settlement period after extension, which ended on (31/3/2022), the society, that is Messrs. So-and-so, had balance amount to be deposited towards revenue fixed by the order dated 29/5/2019, whereby the period of settlement was extended. Period of settlement of the fishery in favor of the society was extended up to 31/3/2020. The tender notice number 1/2022. Contained a condition that if the bidder what is the English of Bakidar?
In case of Pakidar, defaulter,
Was a defaulter, then a tender submitted by such a bidder would not at all be accepted. Full stop. It is not in dispute that Messrs. So and so did not submit any tender in response to the tender notice number so and so, nor the petitioner herein who has claimed that he has been authorized to institute a repetition, had submitted any tender in response to tender notice number so and so. Full stop. Being not a participant in the tender process initiated by the tender notice number 1/2020. Comma. The petitioner it cannot be said that the petitioner falls in the category of aggrieved person as due to his non-participation in the due to non-participation of Messrs. So and so society in the tender process initiated by the so and so. No legal right of the petitioner of the society is found to have been infringed. Full stop. It is not the case of the petitioner that after initiation of the tender process for the fishery by the tender notice number so and so, the respondent AFDC Limited had relaxed any of the conditions in the tender terms and conditions of the tender notice tender document to make the respondent number 6 as an eligible bidder,
valid tender,
as a valid tenderer. Full stop. Full stop. Had it been a case that because of the relaxation of the terms and conditions by the tendering authority, that is the respondent AFDC Limited, after initiation of the tender process in favor of some bidders, including respondent number 6, and thereby resulting in denial of the privilege of the benefit of participation in the tender process to the petitioner. The petitioner might have the locus to institute a writ petition as a person aggrieved, as envisaged in the case of Ramana Diagram Sethi versus so and so reported in so and so, or in Central Goldfields versus so and so. Such is not the case here, and as such, the petitioner is found to be not a person aggrieved as no legal right is found to have been infringed by the order of settlement dated so and so in favor of the so and so. Thus, this court is of the considered view that the petitioner has no locus to present the repetition. In view of the discussion made above and for the region assigned, this petition is found to be lacking in merits and is liable to be dismissed. Most of it is accordingly dismissed. There shall be no order.
Highly obliged, Lord.
Item number 3. Item number 3.
Okay, what are the decisions? Anyway, the decisions referred to by the learned counsel for the petitioner, that is so and so and so and so, are found not applicable to the facts and circumstances obtaining in the case, and as such, the same are not discussed. Yes. Yes, where is MS Sorma? He lovely. How was the conjunction? No. What was that? I have seen MS Sorma. এই এইদিনাখন ডিক্টেশ্যন দিয়ে কিন্তু অনতৰ এটা আছে অনতক মাতিব লাগিব শুনি যাওক অনতক মাৰক ডিক্টেশ্যনখিনি লোৱাখিনি 3-2 niki. Please take your seat. Let MS Sharma come. Hmm. এই দুটো উলিয়ে দিন। To WBC 5-4-6 correction. দুটাকে এই দুটো হ্যাঁ একটু বিশপ টেকনিক্যাল কনফিউশন Yes, anything to be added?
Lord, his seniority was considered while he was promoted to UDO.
Hmm?
He was appointed.
Appointed as LDA.
While
Gradation list.
Yes.
Published.
yes, he was promoted to UDA and his seniority was
Now tell me, what is how the seniority, whether the method adopted by the respondent
Yes.
has any infirmity?
it has to be seniority come merit.
Huh? So what wrong?
Yes.
Come to the order. Come to the order, page 22. I think page 22, right?
Yes, 22.
It is, I think, para 5, right?
Yes.
Respondent was 5 or 6? 6. UDA.
Okay.
He is promoted to supervisory assistant by so and so,
Yes.
promoted.
Yes. And
And enters a seniority of respondent number 6 will be above the petition.
Yes.
Right?
and they,
Now, it is seniority come merit.
Yes.
And there should be a selection.
Yes.
Right, page
Yes.
29.
Yes.
If it, and the district judge, additional district and session judge, assistant district and session judge, munsif,
Yes.
will be part of the selection
Part of-
process. Now come to the affidavit. Of respondent number 5. I think this is the minute,
at page 45,
page 42, right?
42.
42. Now regarding supervisory assistant.
Yes. Yes, 45.
Sorry, 45 perhaps.
45.
45.
45.
Now it is
Resolution number 4.
2 also. 2 also.
Yeah.
From the note sheet prepared by office, it appears no, this is not.
4.
4. 4.
4.
Okay, due to promotion of so and so, serious that are held vacant.
The officer multi however vacant. Next is the amount of property UTSA, that PSA, Dada Sarkar, yeah, and there is Starman, Kamin Kumar Das. Where all
4, in 4, you were not interviewed for what?
yes, I was. Actually, that
Let us see.
after Raja Sarkar UDA,
Huh?
after Raja Sarkar UDA, there is a star mark.
Okay, Kamini Kumar.
Kamini
Okay. 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 So ACRs were
Asia for the 2018,
examined,
19 years. Student.
scrutinized,
You
then
just-
board also interviewed.
Yes.
And board, however, on the basis of interview, as performed by the candidate concerned, decided to promote UDA Suliram as supervisory assistant. It is to be mentioned that
And
filled up by promotion Suliram existing.
And the
Then come to
clause number 8 also important.
7 also and 8. 7.
However, decided not to consider.
Overall assessment of their suitability.
And
Then 8.
the promoting candidate, however, scored higher marks in seniority cum merit, but a higher mark.
So everything hinges on it. Page 46.
Yes.
How do you assess whether it is permissible or not to assess suitability
Yes.
in the criteria seniority cum merit?
Seniority cum. In my humble
It
subject,
is permissible.
but that seniority has to be
Right. So it is permissible
yes,
to
correct.
find out suitability
Yes.
in seniority cum merit criteria also.
Yes.
But what you find, what kind of fault it is?
Because my opinion is that the response number 5, if more weighted in marks rather than skills. The promoting
Yes, and
candidate
Sarma.
scored
My-
higher marks.
Sincerest apologies, Melon. For the last occasion and also for now, Melon. I just gone off to.
Okay, take your breath,
No, Melon.
rest for a few minutes. Let me hear.
Thank you.
the hanging.
Obliged, Melon.
The response number 5, if weighted to only higher marks. And because my qualification eligibility was considered, duly considered.
Now, two things are sure. SCRs for 3 years were considered. Seniority aspect was also considered. Then there was an interview.
Interview.
And on the basis of that clause, it says that respondent number 6 had scored higher marks.
Yes.
So he was preferred. And on the clause 7 said that having considered their overall assessment
Yes.
of eligibility,
Yes.
the petitioner was not considered.
And read with clause 8. The
Right.
promoting
It is to be read with clause 8.
Yes.
7 and 8 are read together.
Yes.
One aspect is that they have given marks in the interview and scored higher marks.
Yes.
That's point number 6. On the other hand, clause 6 said consider their overall assessment of eligibility and was decided not to consider.
In this case, it-
What is the small
Yes,
issue here?
yes, yes,
In between,
yes, yes. It seems they are considered merit cum senior.
not exactly merit cum seniority, but it just takes the color of merit cum seniority, but something went wrong in between 7 to 8.
Yes.
Page
Because-
46.
Just because specifically it was stated when the promoting candidates are, however, scored higher marks than the others.
We should read from MS Sharma,
Melon.
page 46 means your affidavit in opposition.
Lordship.
Minutes of the selection board meeting,
The second meeting, Melon.
17th February,
17th February, Melon.
right? We can read from para 4.
Lordship.
Please read.
Due to promotion to the post of head assistant by so-and-so, the post of civil Shirastadar, office of Munsif Bilasipara is however felt vacant. Candidates, namely Amar Chakraborty, Iftikhar Azad, UDA, both UDAs,
Raja
Raja Sarkar, Sunilam Devada
No.
Adhikari,
There in between there is a star. Go to the left side. Kamini Kumar
Kamini
Das.
Kumar Das,
And
ODA,
Arif
and
Ahmed.
Arif Ahmed, UDA,
Uh-huh.
Sunilam Dev Adhikari, UDA, and Dhiraj Burman, UDA, were called to appear in the interview. Service books and ACR for the year 2018, 19, 20 of the respective candidates are duly scrutinized.
There was no remark about the SCR, right? That petitioner has fallen short in gradings, right? Scrutinized.
Scrutinized. Board also interviewed the candidates personally to test their eligibility. Board, however, on the basis of interview as performed by the candidates concerned, decided to promote Arif Ahmed and private respondent.
So it is clear that there are three aspects. One is seniority, according to seniority, persons were interviewed. Petitioner as well as respondent number 6 and few others.
Lord,
That is one. Second, ACRs for 3 years
with
were scrutinized.
Scrutinized.
No remark else about that. Right? That petitioner had fallen short of gradings on ACR, on the count of ACR. Third, interview the candidates and on the basis of interview as performed by the candidate concerned, decided to promote Arif Ahmed UDA and Suliram Devadikari as supervisory assistant. So on the basis of marks scored in the interview. Right. And clause 8 also, 7 says, because of the marks, he was not found suitable for eligible for promotion. 8 says, promoting candidates scored higher marks.
Lord.
Now, criteria we know seniority and merit. 3 aspects. One is ACR. Considered, scrutinized. Second is seniority. On the count of seniority, petitioner was higher in order of merit as per the selection list.
Great.
Selection list
Selection.
in the post of LDA. And he was also higher in the gradation list prepared for the UDA. So, and it is an admitted position. Come to your paragraph 6. Deponent states that as per gradation list of the Office of the District and Session Judge for the year 2021, Suliram Devadikari, respondent number 6, whose name figures as serial number 13 of the gradation list, is junior to the petitioner in the instant writ petition, whose position is at serial number 11 of the gradation. So then he says, as per the gradation list dated 4/1/2021, the date of birth of the petitioner is so and so and so and so. That is not the criteria for which respondent number 6 was promoted. Now tell me whether it is sustainable
The
that
trust,
on the basis of interview performed by the candidates concerned.
there are two aspects. There was first, well, if I may most humbly draw your lordship's attention to page 42. And Malad, then page
That was
43.
earlier.
That was the earlier Malad. Paragraph 3 is crucial, Malad, to support what I'm trying to advance before this honorable court. Regarding supervisory assistant, UDA Raja,
Paragraph page 42.
page 43, Malad, paragraph
43.
3 thereof.
Oh, failure on the earlier occasion does not mean that you will not.
Yes, Malad, that
Huh?
is one thing, Malad.
One
and-
can sit in the
but the
examination, he can
trust-
fail. Next year he will pass.
Malad, the thrust of the argument sought to be advanced by my learned colleague is that seniority. Well, seniority alone, in my humble submission, cannot form the basis. Malad, in seniority come merit, it cannot be the basis if he is otherwise found unsuitable.
So what is unsuitable?
The interview, my lord, the interview board,
Interview,
lordship,
interview, and
lordship,
respondent number 6
lordship,
scored higher mark.
lordship.
And what is the basis, base mark? What is the mark minimum required to be scored in an interview?
That, my lord, is not evident.
Have you
from-
fixed any mark for
That-
interview also?
That is not,
Then
not to be seen from the pleadings.
not to be seen. Suppose 20 marks fixed for interview.
Lord,
Suppose, then 10 is the passing mark. That element of biasness might be there, discretion might be there. Anyway, let us take for a moment. 10 is the pass mark. I am giving a hypothetical scenario. Petitioner scored 10 marks in the interview, and the respondent number 6 scored 18 marks. Criteria is seniority cum merit. Tell me, whom you want to promote, or whom you are permitted to promote.
10. 10, my lord.
That is a law.
That-
So, is there any reflection about the base mark?
That is not.
Otherwise, it is not permissible, even if in such some situation, maybe the authorities may decide to find out suitability. But just because he has scored better mark, the seniority cum merit criteria, he cannot be promoted in this basis, this page 46, second line onwards. The board, however, on the basis of interview as performed by the candidates concerned, decided to promote,
So and so, and
and read which the promoting candidates scored higher marks than others. You can delay. Okay? Listen.
lordship.
Please, man. Do you have the records?
No, my lord, I don't have that.
There could be two consequences. Subject to correction. If you have a base mark already fixed, you can revisit on the basis of that base mark, taking into account the hypothetical scenario I had given to you.
Yes.
But if there is no base mark already prefixed prior to interview, then everything has to be
False.
redone again from the stage of calling the candidates for interview. Two situations. Already prefixed base mark. Then that has to be considered as per the hypothetical scenario I have given, as per the law settled by the Supreme Court.
My lord,
Or if it is not there, prefixed, but you set in the interview board, go on scoring mark without any base mark, then it has to be redone
whole thing falls apart.
from the stage of calling them. And this man is conspicuously absent, the beneficiary, respondent number 6. Notice has been served.
He has received notice.
Now let us really even again. MS, Mr. Sorry, Dihia. On the other day, Aya Hassan was there.
Okay.
Okay. LN Dihia. LN, right?
Yes, they-
Yes.
Yes.
Mr. S. Jengia, please take a seat. Learned counsel for the petition has contended as submitted, by referring to the minutes of the meeting of the selection board dated 17 to 2022, that all the candidates were called for interview, and it was on the basis of the performance of the candidates, oral interview, scored in the interview, the decision to promote those candidates who have scored better, higher marks than others was taken. First off, both the petitioner and the respondent number 6, along with others, were interviewed by the selection board and as the respondent number 6 scored higher marks than others, including the petitioner, the respondent number 6 was promoted to the post of supervisory assistant from the post of upper division. On the other hand, Mr. Shoma Gulno, Shoma Agot Dihingia. Mr. Dihingia and counsel board of petitioner has submitted that the interview board, the selection board, headed by the respondent number 5, had deviated from the criteria of seniority and merit in promoting the respondent number 6 to the post of supervisory assistant. As the respondent number 6, as it is seen, as it is primarily evident that the respondent number 6 has been promoted just because he scored higher marks than others in the interview held by the selection board. Full stop. There is no indication in the minutes of the meeting that there is a base criteria which a candidate appearing in an interview has to score. Full stop. In the absence of the same, the decision to promote the respondent of 6 on the basis of he scoring higher marks in the interview is liable to be interfered with, as the petitioner at the time of though the petitioner and the respondent number 6 were same date appointees, comma, the position of the petitioner was higher than the respondent number 6 in the merit list at the time of their original appointment in the post of LDA, and the position of the petitioner was also higher than the respondent number 6 in the gradation list prepared for the members belonging to the so-and-so service in the established in the district and station establishment district, which is Thubri. Okay, we'll come back at 2. Either like to, huh? It judgment. The issue which is does fallen for consideration is whether the criteria of seniority come merit as required to be followed for expecting promotion from the post of upper division assistant to the post of supervisory assistant in terms of rule 6 3 read with the note appended thereto, has been followed in the case in hand or not. Yeah. It is well settled principle of service jurisprudence that the principle of seniority come merit, for promotion, is different from the principle of quote unquote seniority and the principle of quote unquote merit cum seniority. First, where the promotion is on the basis of seniority alone, comma, merit does not play any part at all. Full stop. In the event where promotion is on the principle of seniority cum merit, comma, promotion is not automatic with reference to seniority alone, full stop. Merit also plays a role, as merit also plays a role in the matter of promotion on the basis of promotion to be made on the basis on the principle of seniority cum merit. The standard method of seniority cum merit is to subject all the candidates within the zone of consideration and in the feeder cadre possessing the required requisite qualification and experience to a process of assessment of a specified minimum necessary merit, and then and then promote the candidate who is found to possess minimum necessary merit strictly in the order of seniority. Full stop. It is held in Rajendra Kumar Srivastava and others versus so and so, reported in 2010, 1 SSC 335, comma, that the minimum merit necessary for the post may be assessed either by subjecting the candidates to a written examination or an interview, or by assessment of their marks, work performance during the previous years, comma, or or by a combination of either two or all the three of the aforesaid methods. Full stop. There is no hard and fast rule as to how the minimum merit is to be asserted. Full stop. So long as the ultimate promotions are based on seniority, any process for ascertaining minimum necessary merit, comma, as a basic requirement, comma, will not militate against the principle of seniority cum merit. It is also settled that seniority cum merit means given the minimum necessary merit requisite for efficiency of administration, comma, the senior, though the less meritorious, shall have priority. Full stop. Quote unquote, seniority cum merit postulates it is observed in Union of India versus Lieutenant General Rajendra Singh Karian, reported in 2006, SSC 698, that to the effect that seniority cum merit postulates the requirement of certain minimum merit or satisfying a benchmark previously fixed, comma, and subject to fulfilling the said requirement, comma, the promotion is based on seniority. Full stop. It has been further observed that a requirement of assessment of comparative merit is absent in the case of seniority cum merit. Full stop. If an employee is within the zone of consideration, comma, then it is a fundamental right for him to be considered for promotion, though the right to promotion is not a fundamental right. Full stop. Where the promotion is to be based on seniority cum merit, comma, an employee cannot claim promotion as a matter of right by virtue of his seniority alone. And if he is found unfit to discharge the duties of the higher post, comma, he may be passed over, and an employee junior to him may be promoted. Full stop. In a three-judge bench decision of the Honorable Supreme Court of India, and I click on the principle of seniority cum merit para came to be considered by a three-judge bench of the Honorable Supreme Court of India in B.P. Sibaya versus K. Adanki Babu, comma, reported in 1998 6 SCC 720. Comma, wherein the criteria for promotion on the basis of seniority cum merit fail for consideration with regard to same day appointees. Full stop. It has been held that while the principle of seniority cum merit laid greater emphasis on seniority, comma, the principle of merit cum seniority lays greater emphasis on merit and ability, comma, with seniority playing a less significant role. Full stop. it has the decision has further observed as follows. Paragraph 18. লেখা আছে, we thus arrive at the conclusion that the criteria of seniority cum merit in the matter of promotion postulates that given the minimum necessary merit requisite for efficiency of administration, the senior, even though less meritorious, shall have priority, and a comparative assessment of merit is not required to be made. Full stop. For assessing the minimum necessary merit, the competent authority can lay down the minimum standard that is required and also prescribe the mode of assessment of merit of the employee who is eligible for consideration for promotion. Full stop. Such assessment can be made by assigning marks on the basis of appraisal of performance, on the basis of service record and interview, and prescribing the minimum marks which would entitle a person to be promoted on the basis of seniority cum merit. Full stop. Following Sibaya, Supra. BB Sibaya, Supra. The Honorable Supreme Court of India in Hargobind Jadhav versus Rewa City Gramin Bank, reported in 2006, 6 SSC 145, has rated the principle by holding that where the procedure adopted does not provide a minimum standard for promotion, but only the minimum standard for interview, and thus the selection with reference to comparative marks, it is contrary to the rule of seniority cum merit. Thus, it is clear that when the principle of granting promotion on the basis of seniority cum merit is to be applied, it is the inter se seniority of all candidates who are eligible for consideration for promotion is important, and such candidates are to be identified on the basis of length of service or on the basis of the seniority list as prepared. And it is such seniority which gives a candidate a right to be considered for promotion on the basis of seniority cum merit. Following the above principles, it has been observed in Rajendra Kumar Srivastava Supra, as under paragraph 13. Paragraph 13, Thus it is clear that a process whereby eligible candidates possessing the necessary merit in the feeder post is first ascertained and thereafter, promotions are made strictly in accordance with seniority, from among those who possess the minimum necessary merit is recognized and accepted as complying with the principle of quote-unquote seniority merit. What would offend the rule of seniority cum merit is a process where, after assessing the minimum necessary merit, the promotions are made on the basis of merit within bracket instead of seniority bracket close from among the candidates possessing the minimum necessary merit. Full stop. If the criteria adopted for assessment of minimum necessary merit is bona fide and not unreasonable, it is not open to challenge, as being opposed to the principle of seniority cum merit. Full stop. We accordingly hold that the prescribing minimum qualifying marks to ascertain the minimum merit necessary for discharging the functions of a higher post, is not violative of the concept of promotion by seniority cum merit. Yeah. Coming back to the fact situation. No, like that. Rajendra Kumar Srivastava, no? Kiman Kulu. 11 or 13 point. Rajendra Prasad. Rajendra Kumar Srivastava, 11 or 13. I would pass it, pass it. Not like 11 to not like 13. Thirty-two. Sapera, itu Sapera 2 in Rajendra Prasad Supra, Kumar Srivastava Supra, the following two questions arose for consideration. One, one, where minimum qualifying marks could be prescribed for assessment of past performance and interview, where the promotions are to be made on the principle of seniority cum merit. 2, whether the first respondent bank was justified in fixing a higher percentage, in bracket 78%, as the minimum qualifying marks within bracket minimum marks for promotion. তাৰপিছত সাবপেৰা লিখিব answering the first question, comma, the Honorable Supreme Court of India has observed as a while answering the first question, has observed as under paragraph 13. In answering the second question, it has been observed that to the effect that what should be the minimum necessary merit for promotion, comma, is a matter that is decided by the employer, having in mind the requirement of the post to which the promotion is to be made. The employer has the discretion to fix different minimum marks, comma, for different categories of post, comma, subject to the relevant rules. Full stop. It has been cited as an example that for promotion at lower levels, it may fix lesser minimum qualifying marks and fix a comparatively higher minimum qualifying marks for higher post. Whether the guidelines or rules adopted for assessing the minimum necessary merit by prescribing marks under several heads or by prescribing a specific minimum marks, comma, is reasonable or arbitrary, comma, would depend upon the facts of each case. If it is demonstrated that the minimum marks were fixed with the intention of favoring someone or to specifically exclude someone, the courts may interfere. Full stop. Similarly, comma, where the minimum marks are shown to have been fixed to defeat or nullify the mode of seniority cum merit for promotion, comma, there may be a cause for interference. Full stop. In other cases, comma, there is very little scope to interfere with the procedure adopted to ascertain the minimum required merit. Paragraph 18. Paragraph. After coming back to the fact situation, obtaining the case in hand. Comma, it is not in dispute that the petitioner was senior to respondent number 6 at the time of their appointments in the post of lower division assistants on or lower division by order number 31 dated 26/5/2006, as the appointments were made on the basis of a select list published on 19/5/2006. The name of the petitioner figured at serial number 5, whereas the name of the petitioner number respondent number 7 figured at serial number 7 in order number 31 dated 26/5/2006. Similar, comma, in the gradation list published for the members of combined gradation list for the year 2021, published in respect of the members of the district and Sessions Judge Establishment Rubric. The name of the petitioner figured at serial number 11 and the name of the respondent number 6 figured at serial number 30. And both of them are same day appointees. Full stop. It has been found as a principle of service. It isn't found from the discussion above that if the employer contemplates to assess suitability of an employee for any higher post by adopting a process of interview, then it is necessary for the employer, it is incumbent on the part of the employer to fix certain minimum merit or to prefix certain minimum merit or certain benchmark. Full stop. If the employer decides to undertake to hold an oral interview as an addition tool to assess the suitability of the candidate, in addition to scrutiny of the annual competence reports, ACRs, for a certain minimum years and the inter-say seniority positions on the basis of seniority lists, stroke gradation lists prepared in accordance with the extant service rules. Full stop. It is also settled that for effective promotion of the principle of seniority come merit, a comparative assessment of merit is not required to be made. The minutes of the selection board meeting dated 17 to 2022, on the basis of which the impugned decision has been taken, does not reflect any prefixation of benchmark which is required to be achieved by the candidates call for interview, during the interview. Full stop. It has been simply recorded that the selection board has taken the decision not to consider the case of the petitioner for promotion for the time being. After, on the basis of consideration of his overall assessment, on the basis of overall assessment of his eligibility for the higher post of supervisory assistant. Full stop. It has the selection board has further observed that it is on the basis of interview. It is on the basis of the performance of the candidates in the oral in the interview, it has decided to promote the respondent number 6 as supervisory assistant, as he has scored higher marks than the petition. Full stop. There is no reflection that in the minutes of the selection board, minutes of the meeting of the selection board dated 17 to 2020, that there was any benchmark for the candidates prefixed And there is also no consideration as to whether the petitioner had possessed the has achieved the said benchmark. Who's the- The consideration on the part of the selection board while considering the matter of promotion on the principle of seniority should have been that given the minimum benchmark requisite, given the given the given the uh, given the minimum benchmark, given the minimum prefix benchmark fixed for suitability for the higher post, comma, the senior, comma, even though less meritorious on that count, shall have priority over a junior who might have scored higher marks at the interview segment. Poster. But the selection board, in the case in hand, has proceeded to consider the matter by making a comparative assessment of merit of the candidates, including the petition and the respondent number 6, and has thereafter taken the decision to promote the respondent number 6 to the post of supervisory assistant, which is not uh, uh, not a which is not which is in deviation, which is which is a principle in deviation to the principle of assessment settled to be followed for the seniority and merit criteria for promotion. In such view of the matter, the decision to that part of the impede order by which the respondent number 5 has promoted the respondent number 6 to the post of supervisory assistant with the and has fixed the inter se seniority of the petitioner, inter se seniority of the petitioner below the respondent number 6 are liable to be interfered with, and it is accordingly ordered, and accordingly that part of the impede order is accordingly is set aside and with the setting aside of the impede part of the impede or impede part of the order dated, which order? Which order?
Street.
Page. Order number 31 dated 3/3/2008. With the setting aside of the impede part of the order dated order number 31 dated 3/3/2023. In the opposite manner, it is incumbent on the part of the employer to revisit the matter of promotion to the post of supervisory assistant post of. It is observed that in the event the employer, prior to undertaking the exercise of promotion to the post of supervisory assistant, had fixed the minimum benchmark for assessing the suitability of the candidate to discharge the duties in the higher post of supervisory assistant, then in such an event, the employer shall revisit the materials, revisit on the basis of revisit the matter of promotion on the basis of the proceedings of the interview selection board already available. Post of. If there was no prefixed minimum benchmark for assessment of suitability of the so-and-so, then in such a situation, the employer has to proceed with the matter of promotion from the stage of matter of promotion to the post of so-and-so efforts by consideration by considering the cases of the candidates within the zone of consideration. With the above observation, with the observations made and directions given above, comma, the repetition is allowed to the extent indicated above. There shall, however, be no response.
For hearing item number 4, 4 part heard matter.
এটা দ্বিতীয় লিখিছন দিয়া হ্যাঁ এইটো কোন এই তাকে মাতি ৰূপক মাতি দিয়ক নহ'লে নহ'লে দিগদাৰী হ'ব আপুনি মাৰি থাকিব আগত ইমানটা মাৰি Yes, please take your seat. Let me recapitulate, then I'll ask. এই ইলেকট্রিসিটি এখানে সূর্যদেব রায় এইটো নহয় এইটো সূর্যদেব রায় Where is the inspection report? At 16/6 or something like 16/6, right? Nineteen. The matter of investigation and enforcement. The matters of investigation and enforcement have been dealt in part Roman 12 of the Electricity Act, 2003. Also, Section 1-6 of the Electricity Act 2003 has provided for assessment. And the parties have extensively referred to the matters of provisional assessment, final assessment, provisional order of assessment, final order of assessment, and to the appellate order. Section 126 has provided for assessment and section 127 has provided for appeal to an appellate authority from an order of assessment made under section 126. Provisional order of assessment, final order of assessment, and appeal. The provisions of section 126 and section 127 are put in here in below for ready reference. From the provisions of section 126, it is noticed that if on an inspection of any place or premises or after inspection of the equipments, gadgets, machines, devices found connected or used, or after inspection of internal equipment, the assessing officer comes to a conclusion that such person is indulging in unauthorized use of electricity, he will first provisionally assess to the best of his judgment the electricity charges payable by such person or by such other person benefited by such use. Full stop. After serving a copy of the order of provisional assessment upon the person in occupation or position or in charge of the place or premises in the manner prescribed, a reasonable opportunity of hearing is to be afforded to such person if such person files any objection to the provisional order of assessment. Full stop. It is only after affording a reasonable opportunity of hearing to such person, the assessing authority is to pass a final order of assessment within the stipulated time period from the date of service of the order of provisional assessment. Full stop. If the person who has been served with a provisional assessment order chooses not to file any objection and accepts such assessment, provisional assessment, and deposits the same with the licensee, there is no requirement to proceed further with the matter. Full stop. The subsection 5 of section 126 has provided for the method of assessment. If the assessing officer reaches a conclusion that the unauthorized use of electricity has taken place, then the assessment is to be made for the entire period during which such unauthorized use of electricity has taken place. And if the period during which such unauthorized use of electricity has taken place cannot be ascertained, then such period is to be made limited to a period of 12 months immediately preceding the date of inspection. Full stop. The assessment made under section 126 is to be made at a rate equal to twice the tariff applicable for the relevant category of services specified in subsection 5. Full stop. Clause B of the explanation provided in section 126 has provided the meaning of unauthorized use of electricity as per say clause B, unauthorized use of electricity means the uses of electricity 1, 2, 3, 4, 5. From the above, it has already emerged that in respect of electricity meter installation, installed in the premises of the petitioner, 2 inspections were carried out from the end of the licenses, that is on 22/3/2012 and on 16/6/2012 respectively. Though in the provisional order of assessment, the assessing authority had taken a period of 12 months for the purpose of calculating the amount for alleged unauthorized use of electricity. 12 months only kolo niki? Huh? The same made limited to a period of 3 months by the assessing officer on receipt of the objection from the petitioner as the consumer that in the inspection report prepared after the inspection on 22/3/2022, no abnormality was detected in the electricity meter installation of the petition. Para. The respondent APTCL authorities, while raising the assessment orders, that's provisional or final, have referred to. What is it called? Clause 5.A.3 and 5.A.4 of the Assam Electricity Regulatory Commission within bracket Electricity Supply Code and Related Matters bracket close regulations 2004 as amended. framed in exercise of the powers conferred by Section 50 of the Electricity Act. Framed in exercise of powers conferred by Section 50, read with Section 181 of the Electricity Act, 2003. Which one, Mr. Pathak? 5.8.3? 5.8.3.2.c? Alteration. Chapter Roman 5.8.0 colon interference with supply means and apparatus, of which clause 5.8.3 colon malpractice and 5.8.4 method of assessment of the electricity charges payable in case of theft pending adjudication by the appropriate court. Oh no, this is not 5.8.5. No, your provisional order. Let us see your provisional order. You have referred to something. Where is the provisional order, Mr. Bora? 8.4. A heading to heading. Of which clause 5.8.3 colon malpractice and clause 5.8.4 colon method of assessment that is appropriate court are parts as further provided in clause 5.8.1 that a consumer shall not interfere with the supply means or apparatus, including the metering arrangement which may have been installed in his premises. So the sealing of the metering arrangement will be done by an authorized officer stroke employee of the supplier in presence of the consumer or his representative. When an authorized officer or employee wants to break the said seal or otherwise interfere with the metering arrangement, he shall invite the presence of the consumer or his representative to witness it. Where is that clause you are referring to? Clause 4.2.1.2.5 of the regulations 2004 has specifically has mentioned that the consumer shall be responsible for safe custody of meters, cutouts, MCB, stroke CB, etc. What is CB? I don't know. Except in cases where such meter, cutouts, MCB, CB, etc. are installed outside the premises of the consumer. Right? That is your case. Para. The inspection report dated 16/6/2012 contains an endorsement from the authorized representative of the petitioner that to the effect that he was present during inspection and checking and verification of all new seals put by the respondent APD seal personnel. Full stop. The inspection report has further revealed that it was a routine visit made to the premises of the petitioner and CMRI analysis was done for checking the electricity metering installation installed in the premises of the petitioner. The inspection report has further recorded that the installation of cable meant for page 19 of 15 within bracket RPH. It is correctly typed or what?
Yes, sir.
RPH.
RPH.
And 38, 35 within bracket BPH were stripped off over a length of 5 mm to 6 mm before entering the meter terminals inside the cabinet box. Full stop. The inspection report has further recorded that the stripped off portions were found to be covered with pieces of PVC tapes, TAPES, which were removed and sealed in presence of the consumer, i.e., the authorized representative of the consumer. Full stop. It was further reported that resealing was done without rectification of the metering system. Full stop. Assessment bill dated 19/6/2012. Tampering with the metering system was denied. With the contention that it would be impossible to tamper with the meter without breaking of seal. Whereas the inspection report dated 16/6/2012 had found that the metering cabinet was without any broken seal, etc. Allegation was made to the effect that whatever was found inside the cabinet was an act of the APD cell personnel at the time of installation or subsequent inspection. In the final or in the minutes of the minutes prepared by the assessing officer after hearing both the sides on to 22/6/2012, the assessing officer had recorded the fact that the seals and the metering cabinet were found to be intact during the inspection carried out on 16/6/2012. Full stop. The assessing officer had also recorded that the stripping of insulation of CT wares 26 of R and B face within bracket S1, S2 point was found. There was stripping of insulation. Okay. 26. Stripping of insulation of CT wares of R and B face within bracket S1, S2 point, inside the metering cabinet. The assessing officer, while raising the final order of assessment, had taken note of the inspection report dated 22/03/2012 and the CMRI data analysis, wherein no abnormalities were detected in the metering system, to reduce the period of assessment to 3 months. 3 months from 3 months from three months. Full stop. Before the appellate authority, the hearing before the appellate authority took place on 25/7/2012 and 21/11/2012. First of the petitioner side was represented by its authorized representative, who is a partner of the petitioner firm. First of the inspecting officers who conducted the inspection on 16/6/2012 along with other officials were also heard by the appellate authority. The appellate authority had recorded that the inspection that was carried out on 16/6/2012, was in the presence of the authorized representative of the petitioner. Full stop. The appellate authority had recorded that the inspection report had reported that while opening the inner door of meter cabinet during inspection, the inspecting officials found 3 cables meant for connection of R phase CT capital to the H full stop T full stop meter number ASE 59401 that is S1 and 1S2 and B phase CT to the said meter, i.e. 3S-1, page 34, were covered with black color PVC taps, and one of the said CT connection cable was found in naked condition, as the black color PVC wrapped in the said naked condition was found lying in the meter cable. Full stop. It took note of the fact that after arrival and inspection by the said two engineer, by the inspecting officials, the said PVC taps were removed in presence of the appellant and in presence of the authorized representative. And it was after removal of the PVC tips from the said three cables, it was revealed that a portion of the aforesaid three cables were also stripped off uniformly over a length of 5 mm to 6 mm inside the meter cabinet box before entering the meter trap. After the inspection on 16/6/2012, resealing was done in presence of the authorized representative of the petitioner, keeping the said cables as is where is basis condition. Full stop. The appellate authority in its order has recorded that several photographs were taken for reporting the incident. Full stop. Those snapshots, were snapshots, the snapshots of the stripped off cables found inside the meter cabinet. Were also presented during the course of hearing which took place before the appellate authority, and those were also witnessed by all present during the course of hearing. Though it has been contended on behalf of the petitioner in the writ petition as well as during the course of hearing before the appellate authority that the petitioner is not the custodian of the metering cabinet, and as such, the LS mischief could not have been attributed to the petitioner, the said allegation is found to be not supported with any cogent evidence in view of the provision contained in clause 4.2.1.2.5 to the fact that it is the consumer who is responsible for the safe custody of meter, cutout, MCB, CB, etc., meaning thereby the petitioner is responsible for safe custody of the electricity metering installation in question here, as the said electricity metering installation are installed inside the premises of the petitioner. So had the electricity metering installation been installed outside the premises of the petitioner, then it would have been the responsibility of the licensee, that I, the APDC, to be responsible for safe custody of such installation. So the para. Emphasis is laid, emphasis is laid by the petitioner as regards the CMRI analysis data. But such contention has been sought to be repelled by the respondent EPDCL side with the submission that additional report on further analysis of CMRI data, which revealed that the meter was a 3-phase, 3-wire meter. The CT short circuiting cases were not reflected, and the to reach a finding on malpractice, other circumstantial evidence need to be considered. As such, need to be considered. The appellate authority considered the matter of PVC wrappings in the stripped off portion of the cables. The appellate authority considered the statements made by the officials of the EPDCL side that PVC wrappings in the stripped off portion of the cable were found in such loose condition that those wrappings could be shifted as per the requirement of the consumer for short circuiting the cities by using artificial means through optical port opening, which was not sealed. And the statement that the stripped off portion of the cables were near the entry point of the incoming supply cable within bracket I full stop E in the lower part of the metering cabinet bracket close. So it was not it could not be noticed during the earlier visit to the premises during the monthly visit to the premises of the consumer for collecting meter readings and had arrived had recorded a finding that the prima facie evidence has revealed that it was not an act which could be performed by the APDCL authorities personnel during their visit stroke inspection carried out during the inspections for during their visits, so inspections for the electric metering system installed inside the premises of the petition. Easily. And the appellate authority got convinced of the fact that it was the consumer who removed the hinges of the inner meter cabinet doors, keeping the seals intact, and stripped off the said metering cables uniformly, and then wrapped the naked condition of PVC tapes loosely, refixed the hinges and repainted to camouflage. He has referred to data analysis also. To observe that such an act on the part of the consumer had restricted the actual consumption of the meter and caused loss of revenue to the respondent authority. And had gone on to observe that being custodian of the metering cabinet box and the equipments, it is not open for the consumer to claim ignorance as regards the said in such kind of interference with the metering system. So, with such observations, the appellate authority has observed that the responsibility cast on the consumer as regards malpractice has not been discharged by the consumer. With such observations, the appellate authority has concluded that the final assessment bill of rupees 12,66,844 needs no interference, and the appeal has been rejected. And an appeal has thereby been rejected. Full stop. It is The decision. The decision in Rajastri Tea and Industries Limited, Supra, referred to by the learned counsel for the petitioner, comma, is in respect of sorry. Right. The petitioners in Rajastri Tea and Industries Limited, Supra, had instituted the writ petitions immediately after the final assessment was done by the assessing authority under the provisions of Section 126 of the Electricity Act 2000. Full stop. The decision was rendered on the basis of the fact that the assessing officer while the final assessment order did not disclose as to why the final as to why in what manner the objection of the affected person was considered as at the time of passing the final assessment order under Section 126 of the Electricity Act 2003, a reasonable opportunity of hearing had to be afforded to an aggrieved person. In the absence of any as nothing has been recorded as regards the manner in which the objection of the affected person was considered in the final assessment order, the final assessment order was interfered with on the premise that from the final assessment order, it could not be, it did not emerge that reasonable opportunity of hearing was granted to the affected person, and the matter was remanded back to the assessing authority to to reconsider the objections raised by the aggrieved person. First up, in the case in hand, comma, after the provisional assessment order, comma, hearing was afforded, the consumer was given the opportunity to file written objection and hearing was afforded to the authorized representative of the consumer. First up, it was after hearing the authorized representative of the consumer, comma, the final assessment order was passed. Full stop. Modifying the provisional assessment order comma as indicated above. Full stop. Aggrieved by the final assessment order of the assessing officer, comma, the petitioner had preferred the appeal, statutory appeal before the appellate authority. Full stop. Before the appellate authority, comma, all the sides, from the contents of the appellate order dated 10/12/2012, comma, it can be noticed that during the course of hearing, comma, all the stakeholders, including the petitioner, were given opportunities of presenting their versions. So thus, it is not a case that no opportunity of hearing was afforded to the consumer, petitioner as the consumer at the stage of before the assessing authority or before the appellate authority. Full stop. The question of aspect of providing no opportunity of hearing is different from the aspect of inadequate opportunity of hearing. Full stop. In comma, the decision in Rajendra Swenso is found not applicable to the case in hand. The decision in Mukesh Mehra Sutra is as regards dishonest abstraction of electricity and is therefore not found applicable, is not found of any support to the case of the petition. Full stop. It is settled that a an sorry, an appeal. An appeal. More particularly, comma statutory appeal is in continuation of the original proceeding and the power of the appellate authority as regards appreciation of facts is coextensive with that of the original authority. Full stop. Insofar as the finding of determination, insofar as the factual determination of facts, determination of questions of facts are concerned, comma, the appellate authority is the final arbiter of facts. Full stop. Uh, in regard to a finding of fact recorded by an inferior tribunal, that's Saran Singh, right? Yeah. Refer to Saran Singh. Sujyadev Rai. Sujyadev. Saran Singh. It's one thing I asked you. Saran Singh. Oh, it is there. It is there. It is there. Para 13. It is a settled principle of the law that certiorari jurisdiction can be exercised only for correcting errors of jurisdiction committed by inferior courts or tribunals. Full stop. A writ of certiorari can be issued only in exercise of supervisory jurisdiction, which is different from the appellate jurisdiction. Full stop. The court exercising the extraordinary jurisdiction under Article 226 of the Constitution of India is not entitled to act as an appellate court. And as such, comma, there is clear limitation in that findings of fact reached by the inferior court or tribunal as a result of appreciation of evidence cannot be reopened or questioned in writ proceedings. It is only an error of law which is apparent on the face of the record, which can be corrected by a writ of certiorari and not an error of fact, however grave it may appear to be. Full stop. It has been held in Saran Singh Supra. It has been observed in Saran Singh Supra that in regard to a finding of fact recorded by an inferior tribunal, a writ of certiorari can be issued only if in recording such a finding, the tribunal has acted on evidence which is legally impermissible, or has refused to admit admissible evidence, or if the finding is not recorded by any evidence at all, because in such cases the error amounts to an error of law. Full stop. The writ jurisdiction extends only to cases where orders are passed by inferior courts or tribunals in excess of their jurisdiction, or as a result of their refusal to exercise jurisdiction vested in them, or they act illegally or improperly in the exercise of their jurisdiction, causing grave miscarriage of justice. One. Ahora. Suryadev, right? Suryadev. Do you have a copy? Yeah. Itu palu আৰু ইটো পাম চাগে ইয়াতে আছে গৈ এইটো নেকি পেৰা $38. Reiterating the same principle, the Honorable Supreme Court of India in Suryadev Rai versus Ramchandra Rai and others reported in 2003, 6 SSC 675 has entirely observed in paragraph 38 thereof to the effect that 5 3, 5, 6. Certiorari, paragraph 38. Probably Silo ever Mukugu. Certiorari under so and so. Paragraph 5 to paragraph 5 will know paragraph 5. A writ of certiorari is not available to correct mere errors of fact or of law unless the following requirements are satisfied. Colon Roman 1. The error is manifest and apparent on the face of the proceedings, such as when it is based on clear ignorance or utter disregard of the provisions of law, and Roman 2. Underline and a grave injustice or gross failure of justice has occasioned thereby. Where two inferences are reasonably possible, and the inferior tribunal has chosen to take one view, the error cannot be called gross or patent. Full stop. It has been observed as a caveat that the High Court, in exercise of certiorari or supervisory jurisdiction, will not convert itself into a court of appeal and indulge in reappreciation or evaluation of evidence or correct errors in drawing inference or correct errors of mere formal or technical character. The limits of certiorari jurisdiction was kept in mind while deciding the case of Punit Kumar Bagaria, Supra. That is a certiorari was kept in mind, which was a matter which was a writ petition preferred after an order of the appellate authority pertaining to alleged tampering of meter, right? Yeah, it is stated about it is stated at by it is stated by Mr. Pathak that the decision in Punit Kumar Bagaria Supra has been upheld by the division bench in writ appeal number so and so bracketed Punit Kumar Bagaria versus the Assam State so and so. High judgment and order dated 11th 2019. Full stop. Para. Thus, it is clear that the test of perversity of a finding recorded by a tribunal by authorities like the appellate authority under section 127 of the Electricity Act 2003 or an assessing officer under section 126 of the Electricity Act 2003 will be that the finding is not supported by any legal evidence at all. Full stop. One has to bear in mind that the question about adequacy of evidence or its sufficiency or satisfactory character can only be raised in a court of facts and may fall to be considered by an appellate court which is entitled to consider fact, but such considerations are not, but such questions are not to be gone into by this court in certiorari jurisdiction under Article 226 of the Constitution. Full stop. It is essential to bear in mind that the difference between a finding which is not supported by any legal evidence and a finding which may appear to be not supported by sufficient or adequate or satisfactory evidence. Full stop. Having gone through the contents of the inspection report dated 16/6/2012, which was prepared in presence of the authorized representative of the petitioner consumer, with his endorsement to the effect that the inspection was carried out in his presence, and the contents of the appellate order dated so and so. This court is of the unhesitant view that the case in hand does not fall in the first category. The case in hand by no stretch can be said to have fallen in the first category. Full stop. If it does not fall in the first category, it could at best be conceived of that it falls in the second category. And if it falls in the second category, the jurisdiction under 226, certiorari jurisdiction 226 is not to be exercised in such a case. Thus, this court has not found any good and sufficient reason to depart from the view that has been taken by the appellate authority in its order that is so and so. Consequently, the writ petition is found devoid of merits, and the same is liable to be dismissed with. Liable to be dismissed. It is accordingly dismissed. Full stop. The interim order dated 21/12/2012 stands recalled. He is paying current duties. So meaning thereby the appellate order will take place. There shall, however, be no order. Sure. Yes, Mr. Dasgupta.
Item number 2.
It appears to me that the labor inspector has no jurisdiction to initiate any proceeding.
Which part? Which case? Are we taking up another one?
Oh.
2, item number 2.
Two. No, my agenda was item number 4.
5. What is the subject?
Subject is a proceeding under the Pimenta Voyages
I don't
Act.
think it will be possible to.
No, your lordship, can you just tell me The proceeding, so far the proceeding under Payment of Wages Act is concerned, Lord, section 15 of the Payment of Wages Act is relevant. It entirely stipulates that the minimum, only an assistant labor commissioner can initiate a proceeding. Here it appears that a labor inspector has initiated a proceeding.
Assistant Labor Commission.
Labor, that
Okay.
is the mandate of law.
In one case, I have found that labor inspector,
Labor,
no, Assistant Labor Commissioner was holding the charge of labor inspector.
Oh, that is the fine thing.
Then he as a in charge labor inspector filed a complaint. Then he adjudicated it as a controlling authority.
Yeah, here
Anyway.
the state government of Assam also filed an affidavit,
Okay,
and
so
this affidavit supports him.
no, then we'll fix a date
Yes, sir.
as per.
So for the government.
Matter is regarding 1,91,000.
Yes.
And this Bharat Heavy Electrical, they are represented.
No, Bharat Heavy Electrical is not-
Mr. Rava, you represent whom? Huh? BTC.
We are against this proceeding.
Hey, KTM মানে free আছে। কেতিয়া এইটো? 13 যদি অলপ ওপৰত আহিব নহয় দিব পাৰিতো 10th of October 2013 matter.
That's an old pending matter. So it will not take much time.
Mr. Rajgupta and Senior Counsel for the petition. And Mr. Asarava. Land Standing Council BTC for the response number. Any state council, Mr. Setia, you represent.
They
Okay,
filed
Mr.
an
M.
affidavit,
Setia.
that affidavit is in my support.
M. Setia, okay. Junior Government Advocate Assam. 1. Mr. Asarava, Land Standing Council BTC for the response number 2, 3, 2 and 3. And the workmen,
They are not represented.
not represented. They got the money. Okay.
That is,
As sought for, release the case on 10th October. Yes, Mr. Goswami, you are sitting. Any matter?
Matter, last item,
Which item?
item number 8.
8.
So I think
A doubtful case
Yes.
today
today that could be that.
because I have been taking up earlier cases.
Yes.
Is this what? Industrial dispute?
Yeah, it is under that contract labor and.
Contract labor. I'm not very familiar with. Anyway, Mr. Das, you are in the opposite side. Walkman. We can give 12th October,
That is a,
Thursday or
oh yes, that will.
Thursday.
Thursday or Tuesday will.
12th October. Next week, because this is 2017 matter. The cases pertaining to 2012, 13, all are fixed in the next week, right? 12. Because it comes in the, there are nowadays all these 12, 13 matters are top of the list. Okay. P.K. Goswami, Senior Counsel, assisted by Mr. K. Kolita, Learned Counsel for the petition, and Mr. B.C. Das, Senior Counsel for the petition, assisted by B. Sutia, B. Sutia, D. Sutia, as agreed to. This is the case on 12th, 10.
The interim order will get.
Interim order past aggression.
deeply.
6. 6 is of, oh, this is of 2013.
Yes.
12. 12. As who is for the respondent? Yes, Mr. Kolita. Yes, agreed. 12 or before 12. It can be 10 also. 10 কিন্তু ফিক্স কৰিলো।
Item number 5 is fixed on
At 5 is of also 2013.
13.
You are also 2013. Now you need to acknowledge Thursday fees koriম আৰু 10?
10.
Why? Why no? Earlier than that. Huh? So thereafter puja will come. Not later than 12. Or 12 or before 12. 12. Okay. MS and Circle and Council of Petition is present on the prayer of Mr. K. Kolita and Kolita, representing the respondent, Industries and Commerce Department. List the case on 10-10. 12-10. 12.
Item number 2.
Yes, Mr. Khan.
Only order has to be passed.
Only order has been passed?
Order has to be passed. But the hearing is already.
No, I have been passing orders since morning. It is not that I have not passed.
That is true.
It's not sufficient time, but there is some doubt about this case because there are division bench has passed an order. Yeah. Because you were harping upon that notification, right?
Yes, ma'am.
Now it has created more difficulty with the interpretation given.
There are judgments where the government is also relying upon the notification. That there are affidavits filed in other cases where the government is relying upon the notification. I have come across.
No. Affidavit, ultimately, what will prevail? The decision given by the division bench
Yes.
will prevail over government interpretation or single judge.
Division bench.
Right. That para I have indicated.
Yes, my lord.
I have read it time and again.
Yes.
Finding it difficult to come out of the situation because here the fishery department,
Yes, I do.
despite their own notification, did not adhere to that their condition in the notification, right?
Yes.
Like you have argued that the certificate obtained from some authority,
Yes, madam.
NGO kind of
Yes.
authority, you have argued.
Yes.
Notification says it has to be procured or obtained from
We concern.
so and so authority. That was not done by the private husband. Mr. Chetia, on the basis of record now, has come up with the submission that you also did not do so. Is it not?
Yes. But
From the
that is,
records, it's
but
Chetia.
the
From the records, is Chetia.
impure order does not indicate all that. Only impure order says only the PAN card.
But the relaxation that has been given, what relaxation has been given to the respondent has also been given to the petition.
Yes.
So enjoying the same relaxation, you cannot make challenge to the relaxation given by the authority to the private respondent on the same certificate,
But there were-
same kind of certificate.
There are-
That was not recorded by the settling authority. It is your challenge.
there are-
One arrow which hits the Bali also hits the Sugriv. Also hits Sugriv. So same relaxation has been extended to you, Mr.
there-
Count. That is why they have not recorded in the settlement order that both of these have failed on this count. They have relaxed it. Is it not?
that is,
Going deeper, I am finding more difficulties.
and there are some other documents also which we have.
No, basically three. Is it not?
Yes,
Three.
sir.
Yeah, Kolohi.
Fishing experience, caste certificate, then the audited balance sheet,
And 100% acceptable.
What was the same kind of certificate, Mr. Setia?
Yes, my lord.
1 minute. Which certificate of private respondent they are challenging?
Page 64, man.
Caste certificate, my lord.
Let us see.
Yes.
Majority, cast 100%.
Yes, 100%.
Or comprise of members belonging to scheduled caste, right? Let us see, have a look at the certificate.
I have, my lord.
Just, I'll have that.
Yes. Caste certificate of the respondent number
Which,
7
this
is,
one?
respondent number 7 is page
1
32, my
minute.
lord.
This document, similar petitioner's document. I want to have a look at the petitioner's document.
Okay.
This is not. 64 is given by private respondent.
Private response.
Now, what the petitioner had given? Let us have a look at.
My lord, can you record it? Can you, my lord, very, my lord, caste certificate 51, my lord.
51. Okay.
Red numbering.
Red.
Yes.
Red. You are 12 number Jiagolohi.
Yes, my lord.
Oh,
I'm there.
same boat. Riding the same boat
Then there are
to
some
do
other,
fishing. Huh?
there are some other documents also.
Okay, this is gone. Your challenge to page 64 is gone.
Then, my lord, the page 60, my lord,
Page 60.
of the writ petition. This is the fisherman experience certificate.
Fisher.
Fisherman, my lord, that is page 65, red.
This is register of cooperative society.
Yes, my lord, it is by the yes, my lord. In case of my lord, private respondent, it is by the circle officer.
This should be by the
By the-
fishery development.
This should be
By the
as per notification.
as per notification.
Then private respondent.
Then 61 is the Baki.
Private respondent is my lord 29 page.
Huh?
Page number 20.
Which document? Another? Which document, Mr.?
I'm the Baki clearance at page 61 of the writ petition.
Page 61 of the writ petition.
Initially,
There is something is appearing for the society. Asirvad Fishery Mahal Society.
Yes.
Your Bakijai, his Bakijai.
His package, my lord. I have not. Behavior, my lord.
Who is your secretary, Mr.? Who is your secretary?
our secretary, my lord, is
Hemkanto, my lord.
Hemkanta Kormo.
Gone. Same.
Same.
It is bad, worse than page 61. You have to see yourself. See, have a look to your own eyes. It is worse than page 61. Going one by one. See, Hemkanto. That challenge is also gone.
In fact, my lord, PAN card, my lord, in the name of
Our
secretary,
account
my
is
lord,
rejected
in
by
that
the
case,
PAN
my lord,
card.
in that,
1 minute.
in case of,
You are challenging him.
yes,
In respect of which you have also been given relaxation.
Yes.
Right. So your Hemkanto has filed Bakijai. There is no other Bakijai. Page 61, at least the name is also reflected. Asirvad Fishery Mahal Society. I don't know. Above it. Above Kusol.
There is written.
But in your case, not even the name is disclosed. Hemkanto, son of so-and-so. It is worse than respondent number 7's Bakijai. So, your challenge to first one, that's SC certificate. SC certificate
Yes, sir.
or fisherman is gone. Same certificate you have deposited. Your Bakijai is worse than Asirvad. So, you have been given relaxation. They have also been given relaxation. Same hero would hit both Bali and Hugri. All right. Then what is more challenge?
The experience certificate was
You could have said to me at the beginning itself, then all this I should not have invested so much time. Your Bakija is gone and page 64 is gone. What is more in challenge?
the experience certificate, my lord.
Experience. Which one?
Page 60 of my report.
Page 60 of your writ petition. Circle officer. And from where you have given?
he given from ARCS.
Huh?
From the concern authority, he has
ARCS cannot give. ARCS cannot give. It is DFDO, is it not?
DFDO.
page 65, my lord, this certificate.
Page
65.
fishing experience. Which certificate they are relying?
Okay.
Let me see. Hemkanto. This has to be, I think, entire process is to be set aside. Hemkanto. It has to be relooked from another angle.
Because the argument which I was making.
Mr. Setia, whose PAN card has been given by private respondent? Do you know?
Private respondent, my lord,
PAN card.
one in the name of society, my lord.
Society?
Yes, my lord. PAN card,
Which
my
page?
lord, PAN card.
Which page, Mr.?
PAN card, my lord, 43, my lord, page number.
His number?
43.
Okay. Okay.
In case of petitioner, my lord, in the name of secretary, my lord, page 73, my lord.
Yeah, Kiribat. Okay. Let me see there. What story is Vakija is Hemkanto. Victory Root Kanto. From where you have given fishery fishing expense certificate?
Experience, my lord. That I am not an expert.
You have not because there is nothing. There is nothing. That is why you have to annex.
No, in the affidavit filed by them, competitive statement is shown.
Now we are looking into the records.
That I don't know.
As everything is clear as water now.
In their competitive statement, it shows that, my lord,
Forget about all this. Now we are looking into the
no,
record.
my submission, my lord, is that I was saying that the gazette notification has to be followed.
Yes,
So
then
if
we'll look into that, mister.
If I fall, he should also.
No, where is your experience certificate?
If I fall,
Because you are questioning his experience certificate, right?
Certificate, my lord, at page 129, if my lord.
No,
can
page,
see.
where is your experience? Page 60, right?
This is the competitive statement, my lord.
Page 60.
Fisherman certificate is 60.
That is of the private respondent.
Fishing expense certificate, required or not required? Let us
Required,
come to the NIT.
Yes, my required, my lord.
We'll go to the gazette notification later on. Let us see fishing expense certificate. As per gazette, who can give fishing expense certificate, mister?
Gazette notification, the NIT page 45.
No. I have seen page 37 or 45, maybe.
45. মাছ
Assamese version 45.
ধরার-
Ah.
page 45.
মাছ ধরার অভিজ্ঞতার প্রমাণপত্র। Are you questioning his right? Page 60 is what?
That is the fishing expense which was issued by the circle of.
From whom you have given?
Yes, in page 129, that is the affidavit filed by them. It shows, my lord, that our experience certificate was given from circle of
And
M. Kanto property.
then you are questioning his experience certificate given by the cycle officer. Then you are writing on what? You are writing on a certificate
But my submission, my
issued
lord,
by cycle officer. What
all
more?
throughout my submission was that it is the gazette notification.
At least they have a better thing that they have PAN card in their name. You don't even have that PAN card.
That subsequently we got it, but at
That
time
is
of filing, it
all-
was not there.
That is not permissible on the last date of submission. So your writ petition, the challenges on which the documents submitted by the respondent seven are challenged, you also link those documents or you have obtained from the same source.
But
So you got the benefit
it is true, man.
from a cycle officer certificate. The same benefit has been given to them. Both are on equal footing. Now, in addition, you don't have a PAN card in your name, but they have.
So that is the reason why also I was submitting, my lord, that
That is why now I can find out why Mr. Count is stressing so much on notification.
Yes.
I now is submitting so much. Now today I have only seen the records. I have not seen the records, though Mr.
Yes.
So it requires to have a relook on the basis of all your submissions.
My submission was that all fraud that
Both have been given full relaxation.
or if required, my lord, it to go for resale, my lord.
That aspect is to be considered now. Because how much relaxation the tendering authority is giving, it ultimately boils down to nothing. Only after relaxation of 3 conditions to Mr. Khan as well as to the private respondent, it is found out that yes, Mr. Khan is not having PAN card in the society's name. This man has, society has. Let us give it. Relaxation after relaxation, they went on relaxing everything. What sanctity it will have. So if I think, otherwise your bid value is less,
Yes.
It's less,
there is no public interest for interfering.
but there are judgments,
For
my
this
lord,
court.
which says that even a lesser bidder can
Lesser bidder can sell, but he is
inefficiently
to
failed
qualify.
on all counts. 4 documents you have failed to annex. How much is there? You are clearly ineligible. We'll have to have a relook. Please make a list. Tender notice, these are the documents, and petition of society and respondent society. This from which source they have given. Otherwise, recording entire thing will take about half an hour, 45 minutes. Please make a list. Tender notice 1, 2, 3, 4, 5. Baki jai of teaching experience. So petitioner
And respond.
given, not given.
Yes.
Given, if given, from circle of petition. Respondent society given from the FDO, whatever. Just make a list from the records. It will be easier for the court as well as for the parties. We will circulate, we will proceed with the submission. So you have now come to know. Your client hasn't provided the documents that they have annexed. That is a difficult. You are in also very, very bad position, Mr. Khan. এখন আমার রাখিছে না কবাত এখন রাখিছে না গেজেট নোটিফিকেশন আমার আছে না এক্সট্রা কপি due to paucity of time the case could not be taken up today. Mr. Khan petitioner, Mr. M. Setia, learned junior government advocate Assam for the respondent number.
1, 2.
I have found no urgency now in this case.
before a vacation.
Mr. Junior government advocate, huh? 1, 2, 3, 4, 6, 1 to 6. And Mr. As the Learned Counsel Court of Petitioner, the respondent number 7, huh? Present as sought for by the Learned Counsel Court of Party. Time permits, right, Mr. Count? 10 or 12? 12. Now you have seen your position, right? So advance the submission according to it. If the attack on respondent number 6 also drowns you in the water, then don't make that submission. Because same relaxation has been extended to both of you. Just make a list, it will be clear.
Yes, ma'am.
Record to file over, you ভালকে চাই পেলে দি দিম। একটু দি দিও। ভিতর থাকি রেকর্ডৰ কাগজটাও নাই ন তাহলে দি দিব পাৰে। Yes, Mr. Khan, 12. But make a list.
Yes, ma'am.
We have consumed another
Yes, yes.
enough time.